happens to be working with him there. So he has some reservation. So my brother will tell what reservation. He was telling me just.
We can't say, but in our humble opinion, that we might have.
If it is again between my brother and I have no issue.
Objection.
I am ready
don't have
to.
any objection. I think your lordship should not recuse. I should not say that. But then working under your lordship doesn't prohibit from lordship too.
In that case, a judicial officer definitely be connected this way, that way.
And from our side, we have absolutely no
Absolutely no objection.
Who is appearing for Registrar General?
State will be appearing.
State here. State
You are representing. So this
Whether
is
will be happy to appear before my
We will not put lordship in an embarrassing position. We are concerned.
We have absolutely no.
Got full confidence on
Yes,
the
yes.
court.
Full confidence.
we are very thankful, but it is again the call has to be taken by my brother.
I think
I have no issue. I am ready to
my
hear
lords will agree now, because that is not a restraint. Even sitting in full court, whatever the decisions lordships are taking.
In judicial side,
Judicial side, your lordship are deciding that. So
even if one judge suspended a magistrate at the
Yes.
Here
Right,
in judicial side.
in judicial side, they can hear it. So I don't think your lordship. We have been able to persuade my lords.
Let him.
As per Justice A.C. Vera, when the petitioner of the writ petitions was functioning as the first MSCT cum district of Ganjam at Barampur, I was also serving in the same station as the second MSCT, for which I recuse myself to sit in the judgments of the writ petitions filed by the petitioner, believing that my sitting in the judgments of the writ petitions filed by the petitioner may lead others to believe about the likelihood of biasness.
I don't think that part. Okay, we'll do that.
My biasness. Question said.
Lordship doesn't feel that it is proper to hear. Lordship may say that.
But not proper on my part, yes.
Right, the matter was taken up for hearing. The brother judge, part of the bench, for the personal reasons, as stated above, intended to recuse. However, at this stage, the counsels appearing for the parties have imposed faith on the bench and requested the bench to go ahead with the matter on hearing. However, brother judge Justice Behra declined to recuse to hear the matter. Accordingly, leaves the matter before any other.
Place the matter.
Before any other bench, subject to the permission of. That's what he says.
What we request your lordship is,
Now,
we believe that of urgency, lordship may direct the registry to place the matter before the Chief Justice,
Yes.
to list the matter before a bench where my lord Justice Behra is not a party.
Least the matter before any other bench to be constituted by the Honorable Chief Justice. On do you want a date or
No,
let it
urgently, lordship may say.
Thank you. Yes.
Used to be the before to another bench where Mr. Vera would not be.
That was.
Set up for them.
Yes. not surrender.
Yes.
You want extension of time.
Yes. No, extension. Despite the on anticipatory bail, he has directed to surrender and released on bail. But the Donald Master has taken view that his name is not.
What are you challenging?
That rejection of the order of the magistrate.
देखो.
I want to mention, man, simple modification of lordship's of past order, only order date is
Yes.
correct.
Tomorrow.
Earlier I have filed memo,
Okay,
lordship
tomorrow,
was fixed date, but it has not come.
Okay, tomorrow. Yes.
But to make a mention, my lord, IA has been filed for extension of time,
IA for?
extension of time, modification of order.
Yes.
51 and 52.
Let us go. Yes. Any other mention out of this? Yes. Yes.
Any mention from item 1 to 9,
Yes.
item 10 to 20, 21 to 29,
28 mile permitted to it.
With yes. Yes.
30 to 33, 34 to 38, 39 to 46,
Item 44, today's mediation date is fixed, man.
Okay. Awaiting mediation report. Release the matter. Yes.
46 for it.
46 withdraw. Give the memo. Yes.
47 to 52,
51 and 52 months.
Yes.
For matters to be taken off, Mr. Mohan has gone to hospital.
Okay. The Mr. Maharana, Lieutenant Counsel for the Vigilance, is indisposed, and say a request is made on his behalf for adjournment. Release the matter. Yes. 51, 52.
53 to 62,
My lord, item number 53. I am for the opposite party. I have already informed Mr. Senior Counsel, Mr. Dhara. Therefore, for 2 weeks time, your lordship.
Yes.
Yes. Interim order was there.
Entry mode.
Okay.
Yes.
63 to 65.
Item 63, the last occasion your lordship has heard the matter. You think that I have to bring some.
This is
from the charge sheet. I have
Lordship
filed the charge
permits, if a lordship permits, bro, this is that matter. Sangram Das got a notice that you come and take the money. Thereafter, another letter issued to Sangram Das that another person named Sangram Das is staying in the same area. You return back, I return back. There is no pecuniary loss. In that matter, lordship already dictated 3rd lines. And the 4th line is lordship wanted a charge sheet copy for reference. This is that matter.
I'll hear it.
Yeah, what is
I'll hear it.
probably my learned friend is trying to pursue a lordship to take off prior to lunch.
No, I'll try. I'll try. Yes.
My lord, sir, in the same page, item 64 and 65. Both are lengthy matters, my lords. I'm not ready. Let it not today only, my lords.
Okay. Note down करो. 64, 65. Note down करो. Adjourn करो.
My lords, item 64, my senior will appear. I am for the petition, my lords.
But he has some problem. When it will come, I'll just accommodate. Okay. Yes. This. None.
Item 1,
My previous lordship. Lordship, on the last occasion, both petitioner and informants were directed to be present before this, your honorable court. But due to congestion of arrival of Prime Minister, they couldn't reach right now. Within a very short span of time, they will reach. So please
Oh,
let.
pass over.
Pass over.
436 and other offenses are there. So the 436 is can be compared because house has been involved.
I'm just passing it over. Just check it out. Yes.
Please play.
item 2,
My lord, item 2.
Yes.
I am for the petitioner, my lord.
Yes. Yes.
The petitioner's daughter died in a electrocution on dated in the year 2009, my lord. That for which PS case registered before the Satyavadi police station under section 304A, and after final report submission by the police, the petitioner filed a 1cc case before SDM Puri in 518 by 2015. After hearing both 202 inquiry, but learned SDM dismissed the case that the sanction is mandatory. Then the petitioner prefer a revision before the district judge Puri in criminal revision number 70 by YC, who also confirmed the order of Law and Lower Court on YC no YC, then the matter I have filed this case for on the point of sanction. 197 sanction is mandatory, for which both the court
Yes, Mr.
take cognizance, my lord.
Yes.
My lord, that finding of the Law and Lower Court SDGM, that executive engineer, SDO and JE is a government servant, so sanction is mandatory, and no case is made out from the evidence that the cognizable offense. But my lord, that as per FIR, Annexure 1, my lord, as per FIR, page 30, the informant lodged FIR on the date of occurrence that IC Ratnakar Behera, Pita Pandava Behera, Prachanda Nuyapur, Satyavadi, Thana Satyavadi, Jilla Puri, Thana Hajar Hoi.
1 minute, 1 minute. 1 minute, you have not given the copy to the other side.
No, my lord, I have served the copy. I have served the copy.
You serve a press copy, I am issuing notice. Issue notice. Petitioner is directed to supply the copy of the petition to the counsel for the state. Release the matter. Yes.
My lord,
Your Lordship, I am appearing for TPC, let a copy may be served, Your Lordship.
Sorry?
My
Your
lord,
Lordship, I am
served the
appearing for
copy.
TPC ODL, let a copy be served, Your Lordship.
That's what I have said. Let him supply the copy. I issue notice, file the response. Yes. Next.
Puri, my lord, only my prayer so far the 482 application is concerned to surrender first or second order with parity, my lord, who accused already granted bail, my lord. I pray, my lord, that is fine.
Sorry?
Because so far 482 proceedings concerned, I pray only to first or second order bail order as well as parity, my lord, who accused granted bail.
Your bail application has already been rejected.
Twice rejected. My lord.
Twice rejected. How can I supersede that order?
No, my lord.
And that has not been mentioned in the.
You have not even mentioned those things in the petition.
Only I pray, my lord, surrender first or second order with
That's right, but you should have disclosed that you have already approached this court and your bail application has been rejected. You have not disclosed that.
My lord.
You have not disclosed in your petition. Where have you said that you have already approached this court for bail and your bail application has been rejected?
Sorry, I have not mentioned. Sorry, I am extremely sorry, madam. I have not mentioned, my lord.
Sorry will not do, sir.
So, with liberty.
Then the same relief I can't give you.
With liberty, my lord. I pray with liberty, my lord. With liberty, my lord.
For the petitioner seeks to withdraw the petition to surrender before the court on or before 25th of January and resort to the remedy available to him under law. The petition is dismissed as withdrawn with the liberty to the petitioner to appear before the surrender before the court below on or before 25th of January. Till then, and resort to the remedy available to him under law. If after surrendering, if the petitioner move application for bail, the same shall be considered on the same day. Yes.
Obliged.
Yes.
Item 4.
No, please, madam. Herein, madam, I am challenging one order dated passed by learned court below, wherein my interim release, prayer of interim release of my scooty has been rejected. That has been filed under section 457 on the pretext that section 52A of NDPS Act is a bar to release interim release of a vehicle.
No, there is no bar.
There is no bar. And earlier, my last date, my lord has directed to state to obtain instruction whether there is any confiscation proceeding has been initiated
Yes.
or not. And instruction was complied with that there is no confiscation proceeding.
Yes. Yes, Mr. Jana.
My lord.
Where is the impugn order?
That is a page number 10, my lord. And the relevant this is the instruction. That has been recorded that earlier order, my lord. It has been recorded, my lord.
There is no bar. A few days back, Supreme Court also reiterated.
I've also requested one order, my lord. This honorable court has also pronounced this.
Yes. Give me that.
That is enclosed, my lord, annexure 4, my lord. Page number
Annexure
20.
4.
para number 6, my lord.
Yes, so Biswajit Dev versus State of Assam.
Yes. And the trial court has, where is that Supreme Court order you have? That 2-3 days back, there is a judgment.
I'm saying yes, later on.
I'll pass it over, get that judgment.
Okay, now today I'll submit.
Yes, I'll just pass it over. I'll record that and dispose it out. Yes.
Item 5.
2 days back.
No,
2,
may
3
it
days.
may it please your lordship. Item 5, my lord. May it please your
I'll
lordship.
furnish the same today, my lord.
Yes. Get a printout, huh?
My lord.
Yes.
My lord, item 5, my lord. It is
Hmm.
of 147, 148, 153A, 295A, 436, 506, 149. What happened, my lord? After registration of FIR, some person's name are there in the FIR. Police filed charge sheet, and when we applied for the passport, my lord, we came to know that my name is there in this FIR. And previously, the NBW also passed. I am before this honorable court before passing of the NBW, my lord. I am not availed the 438 remedy. Your lordship.
Yeah, I will stay the NBW order. You go and appear.
Your lordship, parity may kindly be passed because
That I'll say. Oh,
My
how many accused are there?
my lord, in the FIR 77 accused are there because my lord, it is a case of someone set a fire in the mosque. It is about
Okay.
2017 and 18 riot issue, your lordship.
Okay.
Bhadrak riot issue.
All of them are on bail.
Maximum are on their bail, but my lord, the present petitioner are not on bail. When they applied for the passport, they came.
You were implicated in the subsequent charge sheet.
Yes, your
Supplementary,
lordship.
supplementary charge sheet.
Yes, my lord. Supplementary charge sheet.
Right on. Petitioner, although was not an accused in the not named as an accused in the original FIR, being Bhadrak Town PS case number 101 of 2000.
Beg pardon, my lord. Beg pardon. In the FIR, the name is there, my lord, but not full name. My name is, my lord, one name is Sanjay Kumar Barik. The name is Bullu alias Sanjay Kumar Barik is there, my lord.
My lord, in the first case, my lord, there are 3 petitioners are there.
Yes.
In the sub-item, my lord, there is one Siddhara Ghade. He has twice applied anticipatory bail, and this honorable court has already directed for surrenderment.
So
The same thing.
Coordinate bench of the
Same thing. I'll say. I'll give date for surrender. That's all.
Then another, my lord, these 3 petitioners are concerned, my lord. The name is there, and whether they have applied or not for anticipatory bail, that can say.
Now show me the impugn order.
My lord, impugn order is at page number, my lord. Your lordship, impugn order is at page number 95, your lordship. 95 onwards, 900, your lordship. 100. 26 August 2020. The NBW order passed against 39%.
Okay. On the request of IO, NBW is issued, right? Petitioner is agreed by the order dated
26 August 2020.
26 August 2020, whereby on the application of the IO, NBW has been issued against them, besides the other accused persons, besides other accused persons. The trial court has issued the NBW as the consistent effort for the IO or to apprehend the accused persons remain unsuccessful, unsuccessful, and the petitioners are stated to have been avoiding the police arrest. On instruction, and counsel for the Mr. Saud and counsel for the petitioner submits that the accused persons would be appearing before the court on or before appearing or surrendering before the court on or before 25th of January 2025 and resort to the remedy available to them under law. Under law. Mr. Tripathi, Mr. Sahu further submits that most of the accused persons out of 73,
75 plus more.
Most of the accused persons are already on bail, and he may be given liberty to move application for grant of bail on all the grounds, including the ground of parity. The NBW issued by the Court of SDJM Bhadrak, wide order dated so and so. Execution of NBW, so and so, we stayed till 25th of January.
Date of surrender not
Huh?
Because if you lawsuit will pass that till date 25th, if you surrender in the meanwhile, the court cannot amend to the first review. Because there is the order for stay of passing till the date of surrender.
Execution of the NBW dated so and so issued by SDGM so and so is stayed
Till the date of surrender.
Till the date of the petitioner surrendering, and moving appropriate application in both the matters same.
My lord, in second matter, the petitioner availed the 438 matter, but he not proceeded with that is order, my lord.
Second matter. Although the petitioner was
Petitioner, only one petitioner.
Petitioner is availed. Where is the date? NBW. Sorry, anticipatory bail.
I have given that.
Yes, this one. Mr. Saul and counsel for the petitioner submits that while order dated 28/6/2024, the coordinate bench, while disputing up ABPL number 5658 of 2024, directed the petitioner to surrender surrender before the court below within a period of 4 weeks. However, the petitioner could not avail the remedy, could not avail the benefit of the sage order. The trial court has now issued NBW against the petitioner by the order dated same order.
Parity also may kind of.
Parity also.
Grateful, my lord.
May I please? Due to non-standard of
Yeah, DBA tender. He has not made party to that.
Matrimonial.
Loknath Mahapatra versus State of Odisha is mentioned.
You have to implement it's a DB Act matter.
DB Act, what happens?
Loknath Mahapatra.
What happens? That warrant has been issued by the court below due to non-payment of maintenance. That case was disposed of. As against disposal, we have filed an appeal before the case.
So what are you seeking in this petition?
Order dated 22/8/2023.
22/8/23.
23.
Oh, go and appear. I'll stay. DB Act. I'll say. Yes, 22.
Private party.
Not whatever, but it is in the execution proceeding. Where is the 22? What is
Case
17.
17? 22/8.
Right.
Right on.
There is a conditional order, 63,000.
Whatever he will appear. Petitioner is agreed by the order dated 22/8/2023, passed by the learned SDGM bracket SDGM. Who is he? SDGM. SDGM Cutter. In execution case number 191 of 2022, initiated by his wife, Lakshmi Priya Das. the petitioner in the execution proceeding has not been included in the present proceeding. However, Learned Counsel for the petitioner submits that submission instruction that his client would be appearing before the court below on or before 25th of January 2022 and resort to the remedy available to him under law. Regarding head to the statement made by the Learned Counsel of the petitioner, the execution of NPW issued by the SDGM Cuttack by order dated 22/8/2023 is state till 25th of January, subject to the petitioner appearing and resorting to the remedy available to him under law. Yes.
Not SDGM
SDGM
Sadar. Within the test.
Sadar. SDGM Sadar कर दिया. Surrendering both SDGM Sadar.
Item 7.
Before placing the case for blood, challenging the order of grant of bail in favor of the opposite party, may I like to place the antecedent of the opposite party. You will also kindly see. And certified copy of the
Cancellation of bail.
cancellation of blood.
You are seeking cancellation of bail.
Blood. Here,
I'll issue notice cancellation of bail.
blood, may I say one thing? Yeah, this is in custody. Your lordship may issue the notice in the address, in the custody address. May post it it's on record everything. May post it sometimes the first
It's
last
all
week
right.
of
Issue notice to opposite party number 2.
both the cases are same, but different like it.
ठीक. Both the case means 7 and 8.
7, 8.
Yes.
Blood.
Issue notice to
I'm
opposite party.
filing Oklahoma today. Maybe Captain Lapa. Or your lordship done, I will file it in the box.
It's all right. Take it. You file it in the registry, no problem.
Well,
I'm issuing notice to the because it's a cancellation of bail. Notice has to go. Yes.
your lordship may have to kindly post it to in a short date.
I will give. Yes. Yes.
Yeah, may have to, also instant is available before notice.
Yes.
Please, my lord. This arises out of a rejection of a petition filed on section 311 here.
You are accused.
Yes,
Show me 311 application.
that application is annexure
4.
4.
Yes. Whom do you want? PW?
3.
Who
His
is he?
evidence is at page 25.
5.
Relevant
What?
fact.
Why do you want him?
Your lordship may see my petition. Why? I have stated in my petition, paragraph 2, that before giving deposition from court, the informant Sujata over telephone called to the witness Malyavanta Mahatma, that means that what she will tell the witness PW3, same will be deposed before court, otherwise she will file another case against him and his father.
Yes. He also mentally threatening manner. Told this out to so. To say something from so. Whether just let us see this kind of questions you have put or not.
No such question was.
No, these questions were put to him, put to her. What is this affidavit?
That is that affidavit filed by the witness, stating that he was coerced by the informant to make the statement.
Yes, what do you say?
In the very fateful day, there is a threatening So PW3 not been lodged in any complaint before the police that
That's
there is a
right.
threatening by the give false evidence before the court, Your Lordship. But that is the different plea, Your Lordship, to not to allow the 311 petition for recall of the PW3.
But that now the accused may proceed against this.
In 311 petition, there is no specific question what will remain to left that the time of
No, the entire what he says that Sujata, he was in relationship with Sujata. Sujata has threatened if you don't depose against this accused. And under her influence, he deposed.
That is their loss.
Something has to be initiated against Sujata. That's what you want to say. Some steps has to be taken against the Sujata because she says influence the witness to depose against the accused person.
In the lordship that is stated that in fact the informant is induced to give false evidence before the court. That cannot be said lordship because that is the stand taken.
But she herself is giving an affidavit.
Affidavit is filed. That is based 30 lordship.
And this affidavit is given before court only.
So annexure file the affidavit is not required before the court.
Are you proposing to take action against Sujata?
The court alone can take. I cannot.
There is one.
But she is influencing a witness against you. You can also proceed.
Unless the witness appears, how can that be done? This is a suo motu power.
No, 311 is something different. What he is saying is 311 it has to be allowed. Because in the face of this affidavit, he has to allow. Because she is giving an affidavit saying that I was induced by someone. So he has to be recalled. That is the one story. Second is you have to take action against you are influencing witnesses.
That is there.
I'll record that also.
Yes, sir.
I'll record that. Right. Petitioner is agreed by the order dated 23. Where is that order?
The order is at annexure 1, my lords.
23/9/2024, whereby the application of the petitioner under section 311 petitioners or one petitioners under section 311 CRPC to recall PW3 has been rejected. The PW3 on 17th September 2024, PW3 deposed before the court. And he was also subjected to cross-examination. Subsequent thereto, the said witness filed an affidavit dated. What is the date? Affidavit date?
Affidavit is dated
1/10/2024 had inter alia stated as under. And the said affidavit was has been filed before the court of JMFC bracket LR Bhubaneswar. Bhubaneswar. On the basis of the state's on the basis of the said affidavit, the present petitioner now contends that the said witness is liable to be recalled because he has deposed against the petitioner under the influence of one Sujata Sahu.
The informant. The informant.
The informant. Sujata Sahu, the informant. The informant. Regarding head to the aforementioned, I am inclined to allow the application moved by the petitioner under section 311 CRPC. Read with section 348 BNSS 2023 and direct the trial court to afford a singular opportunity to the petitioner to further cross-examine the PW 3 on his recall. The trial court is directed to fix a particular date and afford opportunity to the petitioner to cross-examine the said witness. Regard being head to the peculiar facts of the present case on the basis of which the present application is allowed, I am forced to observe that the petitioners are not precluded from proceeding against the informant in accordance with the law for having influence influence the witness.
My one more section also the affidavit, which is my learning since relying, whether that was filed before learning trial court, there is no reflecting in that affidavit. Because
it is written there. I have recorded. It's not filed, then consequence will. I have only said that it is it's not precluded. They can take in accordance with it. No, para लिखियो ना, para 1 to 5. 1 to 5. ठीक है? Yes.
Item 10.
My lord, was alleged to have committed transporting 7 kg and 100 gram of ganja in which 10, my lord, in which the trial court has granted bail and he was on bail also.
What is?
Sir, these are bicyclically released on bail.
Trial court, my lord.
Vice date of MW. Okay. 12 is a vice date of MW. 7 is a vice is the bail.
Okay.
But the petitioner was a lady, he was on serious ill,
You have to
for which she was not attended the court.
Okay. Allow. Yes.
My lord.
11.
11, lordship, partial after.
Your lordship, item 11, it's a CBI matter. We'll seek instructions in the meantime. Your lordship will file a reply.
Okay. Counsel for the CBI seeks an adjournment to get instruction in the present matter. Limit the matter also.
Much obliged, your lordship.
Yes. Next.
12.
498 case. I am questioning the jurisdiction of the trial court and the police
Let us issue notice.
to investigate the case which has taken place beyond the territorial limits, madam.
498A, we will see. Try to settle. Wherever, whichever police investigate,
Yes.
the end result, it will be settled. Today or tomorrow, it has to be settled.
House of the present petition will accept the culture. See, lost the affair for the culture.
I issue notice.
The FIR reveals that the incident took place at Puri and Subarnapur. So where does the Talcher police get the jurisdiction, or where does the trial court at Talcher get the jurisdiction, my lord? It violates 177. With due respect, let my learned friend read it, my lord.
I issue notice, let us see. You accept notice.
But there is a settlement before the cultural also. Due to Pendant House, there is a settlement before the cultural also. If there is no any cause of action, then
Yesterday also I told you in matrimonial dispute, don't go by technicality. Try and find out a solution how to get it resolved. That's the only object.
He is a judicial officer, my lord, petitioner.
So there is more of a reason that he should settle the dispute. Jagdish Jana is
out the allegation of Subarnapur approach not taken any action. Police not taken any action before the Subarnapur.
That will close the police at Talcher to give jurisdiction, my lord.
What is the stage, by the way?
Charge sheet has been filed.
Only charge sheet is.
Yes.
I issue notice after 1 week before a review. You immediately take step. We'll try and settle it here. Forget about the technique.
Settlement, they made some attempts for settlement and somehow failed. Okay, again, we can try.
Settlement can happen anytime. It's a matter of a momentary thing, We'll try.
Then further proceeding or something.
You move application. He will move applications for adjournment. Just charge it. Yes.
30.
Issue process.
It's an application regarding rejection of my 457 application, your lordship, by the learned trial court and was subsequently confirmed by the learned appellate court, your lordship. Here, your lordship.
Release of what?
Release of cash, your lordship.
Cash.
Initially, lordship,
you have filed 3 petitions.
Initially,
how many petitions? Gambling. 1, 2, 3.
No. We have 4 petitioners.
You have 4 petitions, but 7
Let me explain, your lordship. Here, your lordship, initially the case was registered under 3 of Orissa Prevention of Gambling Act, your lordship, in the year 2022. After 5 days, the seizure list was produced before the learned court below. And your lordship may peruse the annexure 5, page 42, your lordship.
Page 42. Okay.
Last para, your lordship.
Yes.
The case is turned to 420, 120B along with 25 of
Interstate Migrant Workmen Act, Your Lordship. The Gambling Act has already been gone, Your Lordship.
The cash is
The cash is
seized from you,
cash seized from us, Your Lordship.
all of
Yes.
separate.
When we filed an 457 application, Your Lordship, before the court below, stating that we are the contractors and had been to the place to take
What is
laborers.
the cash, you tell me?
Cash, Your
58
Lordship.
lakhs some.
Total.
They've shown 58 lakhs, Your Lordship. These four petitions.
How much you tell me?
74 lakhs, Your Lordship. But
What is the seizure list says?
seizure list 58 lakhs, Your Lordship.
58 seizure list is 58. Where from they'll get it now?
Yes,
Your
now
Lordship.
the law
On the
enforcement
same reason, Your Lordship.
You furnish some security and take it.
Okay.
Get instruction.
yes.
Property security, indemnity bond, let him
Yes,
give and
yes,
take it the case. What will you do with that case?
But the paragraph.
See now today what happens? You have taken 58 lakhs
58 lakh.
and now he says 74.
24 lakh.
And
Yes.
he'll keep some more time he'll get some crore of it.
Lordship.
Better give him.
There are four petitioners, Your Lordship. There are four petitioners.
All right, let him seek instruction. You get ready.
Four petitioners, total 74 lakhs, Your Lordship. I have filed 4 applications, Your Lordship.
Whatever is the amount seized, which is
Proportionately-
reflecting, that will be reported.
Proportionately, that will be disposed, Your Lordship.
However, you have to furnish the security
Yes, Your Lordship.
in individual case. He'll
Yes.
let him get instruction after 1 week. Issue notice.
Next Monday, Your Lordship.
Monday, Tuesday, they give you. And you just get the instruction. Huh?
Yes.
It's the instruction. He will furnish security. What kind of security will give? Bank guarantee.
Bank guarantee.
I will take instruction regarding that. Yeah.
You tell me what are the security you want to furnish. I'll release. Cash release subject to security. Okay. Simply issue notice. Least after a week. And
Date may be fixed, Your Lordship.
you just tell me. I'll allow it. Okay. And tell Mr. Maharana, tell Mr. Bishwal what is the security you want, so that he'll seek instruction immediately.
Yeah.
Don't wait for the next.
2022, it's pending, so let the date be.
After 1 week, I'm giving.
Yes.
And today only seek instruction. Pass on the message to him so that he get the instruction.
Yes,
If you have an objection, next 17th, I'll allow it.
Yes, Your Lordship.
Okay, but today you have to pass on the info.
Yes, Your Lordship.
In writing.
Yes.
In writing.
With an
As
application.
it fell from the court, this is the suggestion. You just seek instruction immediately. I'll allow it. Okay.
14, my lord. This is a 138 case, my lord, judgment against your lordship 49/11/2024. Your lordship, see the check. I'm placing why, my lord. Your lordship, read the check.
What are you challenging?
There is judgment dated 29/11/2024.
Conviction order.
Conviction. Your lordship, see how they have convicted. That is,
Yes, then you have to file an appeal, sir.
your lordship, appeal there, my lord.
So then after conviction, appeal has to be filed. How can you resort to 482?
Time limit, your lordship granted, I will file an appeal.
File it.
Your lordship.
Rather, what I'll do is on your oral prayer, I'll convert it to an appeal. Why to waste time?
Your lordship.
Okay. Petitioner in the present petition has challenged the judgment and order dated 28/2/2023 passed by JMFC. First, JMFC Sambalpur in ICC case number 136/2023, convicting the petitioner for alleged offence under section 138 NIA and sentenced and passed an order for sentence.
Beg to pardon, my
that count on that count.
Beg to pardon,
He
my
has resorted to
appeal district juror.
yes, sorry. It's then counsel for the petitioner seeks to withdraw the present petition to prefer an appeal against the state judgment and order of conviction and sentence. With liberty, the petition is disputed. What protection? Huh?
Protection.
What protection?
I
I can't do it in a petition which is not maintainable. How can I pass an order?
Within stipulated time, your lordship.
That is the limitation is there. Section 14 is there.
Your lordship.
Section 14 benefit you will get it. You need not worry about
And your lordship.
litigating before a wrong forum in a wrong proceeding. That time will be excluded. Section 14. Yes.
Item 50.
Convicted under PCF now, sentenced for 3 years.
Item 15 to 21, fresh admission, my lord. I am in virtual, my lord. Am I
Let us go.
audible, my lord?
Let us go one by one. 15. Yes.
I for bail and stays there.
Huh?
I for bail and stays there.
Yes. Bail granted. Stay of reliance. Yes. ERC court. Yes. And 16
also conviction.
same. 16 the same. And 17 also. And in all the matters, Mr. Sanjay Das. Yes. 17.
My lord, item number 17, he is in custody.
You are in custody.
Yes, sir.
Except item number 17, all others are 3 years.
Sentence?
4 years.
4 years. Grant bail. 17 of first प्रथम को दे दो अध्ययन को ठीक है grant bail.
And fine out.
18.
18 also same. 19 also.
19, 20, 21.
20. ठीक है. Okay.
Obliged, my lord. Free copy.
21 तक. हाँ. Das.
22.
Obliged.
22.
22.
Pass over.
Your Lordship, item 22, it's also a CBI matter. We'll seek instructions in the meantime, Your Lordship. Your Lordship may issue notice.
Don't show APS for the CBI and seek an adjournment. You want to file?
Yes, we'll file a count.
Counter. 2 weeks time granted.
It's a revision against order rejecting discharge, Your Lordship.
Give your name. Yes.
23.
May I please, Lordship? That is, Lordship, the matter, the Belgium matter. The NBW issue against the present petition on dated 26/11/2024. Petition on bail 16/8/2023.
500.
24.
Public.
24 million. NBW issue on 25/4/2024, Lordship. And my lord, the bail, present petition was on bail, Lordship. But bail date has not been taken.
You are on bail.
317,
500.
my lord, obliged, Lordship.
5.
May I please, Your Lordship. Now the matter relates to Belgium, Your Lordship. NBW issued on 16/8/2024 and the petitioner was on bail on 12/5/2022, Your Lordship.
522 bail and NBW is
16/8/2024.
ठीक है. 500.
26. My lord, challenging the NBW which has been issued at page 25, my lord.
Yes.
On 17/6/2024.
Yes.
It is a claim arising out of a 2cc under DNC Act. The lady who is the doctor over here, she was not directly involved in it.
Forget about it.
What had happened, my lord?
You are an accused in 1cc, 2cc case.
Yes, my lord.
And NBW is issued. Where is that order?
Page 25, my lord. Bail order Your Lordship, anticipatory bail was there. Your Lordship, may kindly see page 21 also.
21.
Yes, my lord.
What is that?
I had applied for an anticipatory bail that was granted.
It's all right. You go and appear once again.
Yes, my lord, I will appear. Appear and release.
Petitioner was although enlarged on anticipatory bail by the order dated 28/4/2016 by this court while allowing ABPL number 3957 of 2016. But for his default in appearance in the court, NBW has been issued on such and such date. 17/4/2024 by the by learned SDGM Parampo in 2cc number 718 of 2012. Yes.
27.
Yes, 27.
But the 307 is there. Injury report, Your Lordship may call. And grievous in nature is the page 13 in the rejection order source.
Page 13.
Yes, madam.
Yes.
Third para, third line. Causing grievous injuries. Your Lordship may call for the injury report.
Which para third?
My lord, page 13.
Yes.
Annexure 2 is the rejection order.
Yes, yes. Which part?
Para 3, fourth line.
Injury report from Mr. Barampur is yet to be obtained by the IO.
Yes, ma'am.
You obtained it?
Yes, ma'am.
Have you obtained?
No, no.
The injury report is required to obtain by the, yes.
Item 27.
Hmm.
In this case, my lord, co-accused granted bail.
Injury report, show me the injury report. Do you have the injury report?
27.
Give me. Co-accused bail. You are in custody since?
Custody 2011-2020.
2011?
2024.
The present petition is the principal accused.
He's the principal.
307.
Get the injury report. Get the injury report.
20.
27.
27 injury report.
Injury report, na?
Yes.
Although co-accused, your lordship granted bail.
Yes, yes. Get the injury report. And
Injury report with me, my lord. Your lordship kindly see.
The custody since?
Custody, my lord, 20th January 2011. 2011-24, my lord.
Injury report. You obtain it and 1 week. 1 week. Okay. You obtain it. Yes.
A short date may be given.
1 week. 20. What happened to 28?
28 not press. Already case was closed for.
Yes. 29. Yes. Affidavit filed, not filed. Next week. 13, 13. Yes.
30.
Thirteen. Yes.
31.
May I please, your lordships? Offense under section 302, my lord. The petitioner is in custody since 3/8/2023.
3/8/2023,
my lord.
Yes.
My lords, on last occasion, my lord, the state had stated that 2 vital witnesses has to be examined.
They have
Have
deposited.
they been examined?
Yes, ma'am.
Yes, ma'am.
But they are hostile, my lordship. In 164 statement, they said what happened. But in depositions,
The brief fact of the case is that, my lords, the petitioner and the deceased, my lords, are 2 friends who went to consume liquor, my lords. And one of the friend returned and another friend, my lords, on the way fell down from the culvert and died, my lords. This is the postmortem report I'm submitting.
Krishna Chandra Chaudhary and G. Ravindra Reddy.
Yes,
my lord.
yes, my lord.
Examined.
Yes, my lordship.
Everyone is saying that both of them brought liquor, disposable glass and cigarettes, and thereafter they went, my lords.
Together, but one friend returned and another was not returned. And at 4 o'clock, the person who returned, the one friend who returned, he just went to his house and asked about another friend, because all I've seen, they both have gone to the Sankar to have the liquor. But one friend returned and go to his this is home and asked him.
Whether he has returned or not.
No, at 4
When-
o'clock.
Yes, ma'am.
Show me the evidence of these two witnesses.
Yes,
Krishna Chandra and
164 statement, my lord.
No. Now
Deposition, my lordship.
Deposition.
May I please, your lordship?
Yes.
In the cross-examination, my lordship, I cannot say how many people came to my shop on 2023. It is not a fact that I have not.
Then what is there?
Yes, my lordship, so because of the circumstantial evidence and my lordship, medical examination, medical opinion of the medical
May I
officer.
read the relevant portion, my lords. In the while examination, he told that after 3 days he returned, but he replied that he doesn't know about the cause of death. The present petitioner, my lords. When the PW8 asked him, what is the cause of death? He told that I don't know the cause of death, and this is the reply, my lords. And the allegation is that, my lords, both of them went together and he saw the dead body in the morning.
You are opposing.
I am opposing, my lord. My lord, this is not directed.
What are the material?
Materials, I am one by one, I am clarifying, my lord.
Yes.
Chain is complete. Because deceased and accused both are seen together prior to the occurrence. The evidence of PW7, mother of the deceased, she has stated that PW7, she has stated that deceased called the
PW7.
PW7, man.
Yes.
On PW7, para 2. On 25-23 at about 9 p.m. S. Diban Reddy called my son with him to consume liquor, but my son did not return in the said night. And in the midnight at about 3 a.m., S. Diban Reddy came to my house and asked my son, to which I replied that my son had gone with you at 9 p.m. and why you are asking me about him. In the morning of the next day, the dead body of my son was lying under Culvert Sankar near the end of I went to spot and found the dead body of my son. Then
That's the mother's state.
that is the mother's stand. So, deceased was called by the accused and the accused called with the deceased gone with the accused. Then the evidence of PW8 and 9.
Yes.
PW8 evidence, question PW8, PW9. I have a beetle shop and I have got license to
8 or 9 you are reading?
8 and 9.
Which one you are reading now?
PW9. I have a beetle shop and I have got license to sell liquor in my shop at Orsing Chowk on 25-23 at about 8:30 p.m. Babula Reddy along with S. Diban Reddy, present petitioner, came together to my shop and Babula Reddy purchased 6 number of liquor pouch from me and went together.
This is the allegation.
That means
purchase.
They have purchased liquor and the corroborating the evidence of PW7.
What is the name of the disease?
S. Diban Reddy.
And S. Diban present petitioner, Babula Reddy.
Babula Reddy.
The Babula Reddy was found with
that is the
last seen together, they consume liquor. And another evidence,
PW2 also, my lordship.
PW2 also.
Last scene is proved.
Last scene.
Apart from that, what?
Apart from that,
yes.
Well, kindly have a glance to PW2 evidence.
I take it. Last scene.
Last scene theory.
Yes.
And also,
what else?
Then the accused has explained how the deceased died. Number 3. And the regarding post-mortem report, what my friend has submitted. Internal findings, the under surface of the anterior, though post-mortem report is a corroborative, medical evidence is a corroborative evidence, but that supports that the
yes,
it is a homicidal. Next, the internal findings paraphy. Neck, the under surface of the anterior neck muscle is intact. The deep marked muscle surrounding the vertebrae are contained. Fracture 4th and 5th vertebra with lacerance of the spinal cord.
Yes.
My lord, may read the opinion, my lords. The first part, the above mentioned external injuries are antemortem in nature and could have been caused by hard and blunt force impact coming in contact with rough surface. The above mentioned neck injury can be possible by fall from height, my lords.
That cannot, column number 2, the postmortem dicta, that's if that would be asked the postmortem doctor, but the over anxiety the postmortem, but column number 2, opinion of assistant surgeon. Death was due to spinal shocks as a result of the above mentioned spinal cord injury. Another
might have been fallen.
Another thing, my lord, the case is posted to 16 and 17.
My lord, more than 1.5 costed, my lord.
16 and 17 of
16 and 17.
For what?
For the evidence of rest of the witnesses, and the evidence will be closed on that day, 16 and 17.
Total 31 witnesses are there, my lord.
No, the other witness,
On earlier occasion, they told that the
on 20th.
mother is the vital, my lord. My lord,
Listed on 20th. 20th you from.
every time they're saying this is the vital.
Whatever, maybe I'll can't pay.
Yes.
There is nothing. Except last in theory, you have nothing.
That will be the final date, my lord. So,
That is the final.
yes,
20th.
my lord.
32.
24th.
No, 20th. 16, 17 is the date. 20th.
21. 30 I also person, 21.
21st. Okay. But get the deposition.
My lord, I'll get.
4 witnesses have been summoned.
Certificate copy is not required. Just get that. Yes.
This case on some 498, 302. And it's by
30?
the husband.
Yes.
My lordship, CD is not it. Sir.
CD.
Yes,
Waiting
ma'am.
CD. Listed. Yes.
33.
I beg pardon, my lordship. Item 30, item 30, my lordship.
I'm in 33 now.
My lordship.
Yes.
May please, your lordship. Last occasion, State Counsel said that he has obtained the CD and taken time to go
But
through
it was, my lordship, the bill petition number 3023 of 2024, which was rejected by this honorable court, and the CD was in that. But today I just kindly pass
But
over
this
or
is the
my
sixth
lordship.
time, your lordship. Prior to that, 3 times. This is the 6th
Okay.
time, your
Okay.
lordship.
If he says, let us pass it over.
Pass it over, my lord. After lunch, I will.
Yes. No, keep it on 13th.
Your lordship, it's a master tribal offense. The innocent
Okay.
person
Pass over. Yes.
That, your lordship.
34.
My lord has granted up to grant bail to some co-accused person. Let me examine.
Okay. You want to examine it, let him examine.
Next week, Monday as well.
Next.
Specific Monday. I prefer Monday because
13th. Okay.
So next week, next week Monday ko
Monday after go to Monday after go to red then kar do
Monday after.
Monday after.
I'll just
Okay, next 37.
My pleasure, Lord. The item 37 last occasion, my lord, seeking for direction to submit regarding the chemical examination report, my lord. But after gone through the entire charge sheet, I have not seen any criminal.
Yes.
Any chemical examination report, my lord.
Antecedent of the accused persons.
There is no antecedent.
No, chemical examination report is there or not?
No, man. No.
That was the direction.
I have obtained the
counsel for the petitioner is directed to verify whether the chemical examination report is present in the present case has been filed along with the charge sheet or not.
I have obtained the entire certified copy of the charge sheet, my lord. There is no any chemical examination report, my
If
lord.
there is no chemical examination report, is entitled to bail. Call for CD.
My lord, there is no antecedent, my lord. Antecedent.
Okay, call for CD and petitioner is to file an affidavit regarding his antecedents. Yes.
Let me sort that, my lord.
Yes.
38.
38, my lord, this application is filed for restoration of CRLMC, which was dismissed for default on 24/3/2023, my lord. It was stay was there, but on 24/3/2023, my lord, immediately after division bench rising, single bench at 4 o'clock, it was taken up. Held up in another court.
For the reasons stated in the application, the CRLMC number 1184 of 2018 is restored to its file. This the CRLMC for hearing. Yes.
Bless me.
39.
Notice is necessary to be issued to the opposite party as a respondent. The same appeal has been filed for restoration of second appeal, which is dismissed on 26/2/2020. Limitation petition has been filed along with a petition for dispensing with the certified copy of the order. The lordship may
delay. How much delay?
Delay, your lordship, near about 5 years, your lordship. But notice is necessary, your lordship. What is their objection there?
No. 5 years delay, you have to satisfy. You just see your.
It is your lordship. This is only due to communication gap.
Communication gap for 5 years.
Lordship, no correspondence. There was no correspondence between the
plaintiff, appellant
Counsel for the
respondent.
appellant is prior to the order of dismissal dated so send a number of letters and also try to contact but no response was received by the appellant due to the communication from what. Show me one letter.
Lordship, kind.
You have said that you have written number of letters. Go give me one letter.
Lordship, keep it any other day. I will.
No. These are the frivolous petitions.
Lordship, they are ignorant.
After 5 years, you have filed
Lordship, they are ignorant.
restoration. You say that I have given number of letters to the lawyer. Show me one letter, I'll condone it.
I will
Now pass it over, get it.
Lordship,
Pass it over. It is very easy to blame the lawyers.
No, I am
What
not-
were we doing?
Lordship, I am not blaming.
That is you say that the lawyer is not have communicated. I have given number of letters. Give me one letter.
Lordship, I am saying that I have communicated the letters to the parties. They did not arrive because of.
Show me one letter.
Lordship, I will show. Lordship, keep it any other day. I will collect.
See, your condonation of delay is only that. If you don't file document, why should the court will believe your oral this thing and condone the delay of 5 years?
Lordship, this is the substantial right is to be decided. Lordship, though.
That's right, but you have ignored the right.
They are the
your own-
scheduled tribe person. They are ignorant regarding the procedure.
All the
of
things
law.
are there, but sufficient reason has to be shown.
Lordship, keep it. I am satisfied. Otherwise,
Next week, the queue. I'm prima facie, this court is not satisfied on the explanations offered by the petitioner to show sufficient cause for condonation of delay up to 5 years. The counsel for the petitioner want to file the documents and additional affidavit to explain the delay. By way of last opportunity, 1 week time granted, lease the matter of home. Yes.
Item 40.
Yes.
Getting appearance in two of the evidence. Two cases are there.
Opposite party?
No. Petitioner. Mr. Agarwal earlier conducting the case. Bola.
You have taken.
Today I have been given the vakalatnama. Can it be taken up tomorrow?
Not tomorrow. You have changed the counsel because you have an entry model.
No. He has gone to that side. So that is the problem.
Additional continue. So entered appearance for petitioner after obtaining no objection from the counsel. Lease the matter date the entry model to continue.
Great.
Yes.
41.
That item 41 notice has not been issued. The previous counsel has not taken any step for issuance of notice. But now I am appearing. So I will give 1 week time. I file the requisites.
Yeah, now you entered appearance. Entered appearance for opposite party and the 1 week time to file
Yes.
counter. Lease.
Yes.
Yes.
42.
My lord, in this case, petitioner challenging order of a cognizance, my lord. Earlier notice had gone. Notice was served. Again notice had gone. But noting
service press notice.
Address is left without instruction.
Yes.
in fact matter was settled within the party earlier. Affidavit also was filed before this honorable court and others CRLMC. I have annexed also.
But on merit, if she is not coming, we will have to see 376.
My humble prayer, your lordship may adjourn it.
No, how many? See how many hearings, just check it. 1, 2, 3, 4, 5, 6, 7, 8, 9. 9 hearing. Cognizance order.
And in that affidavit, my learned senior is relying that affidavit is filed in CRLMC number 23235 up to the 19 or.
My humble prayer, matter may be listed along with CRLMC number 2335 of 2029.
Annexed 2 year also page 11 year also. My affidavit is my learned's brother is relying that affidavit was up to the 19 matters also. And this
See, if you
23.
say that you have settled the issue with the prosecutory, at least it is your responsibility. Bring her. I'll quash it.
But I am trying, but
the court has attempted many times to issue notice and try to serve.
But petition,
court has failed. Then it is your responsibility to bring her. How? What can I do?
My humble prayer, your lordship may list it matter along with the CRLMC number 2, 3.
What will, along with the CRLMC, she will come?
But no, but order was passed. Then
No. You are relying upon an affidavit given by the prosecutory that she has settled the dispute with you, and on that basis you want passing up for the cognizance order. Unless you bring that prosecutory here, how I will verify that?
As your lordship may adjourn some
9 hearings, sir. I have given 9 hearings, 9 times.
But I am
Just imagine.
But I am trying, though matter was settled.
You bring him. See, I don't think. You do one thing. I will give you liberty on the basis of this affidavit. Go and in the trial court agitate in the time of framing of charges.
My humble prayer, your lordship may at least last.
No, that is a better idea. I'll tell you, because the trial court has option of issuing NBW, whatever. I can't issue. Because she is a witness. She is the prosecutory. Trial court can issue the process, harsh process, but I can't issue harsh process in a quashing petition.
I shall instruct to the petitioner to try.
No, better. I just record everything and relegate you to the trial court. The trial court has the power to issue harsh process because she would be a witness.
So may I pray before your lordship this matter may be listed 2335 something here.
Tomorrow along with the other matter.
Well, next week, my lord. Next week, my lord.
The bail application, what will happen?
No bail application, one CRLMC also.
2335 of the 19 matter.
Though in bail application, Honorable Court noted that though matter already been settled, you should do act.
So that is the reason, sir. I'll tell you, if I'll send it to trial court has the power to issue harsh process against the prosecutor who is a witness.
I'm understanding.
But I can't do that. Why don't you appreciate that?
Because till yet petition has not been granted bail. Petition has not been granted.
That is a different story altogether. You are seeking passing up for cognizance order. I can help to that extent that I'll tell the trial court that you decide.
As last chance, your lordship may adjourn next week. You will try to bring
it along with this next week. I'll not adjourn. It is made clear that no further adjournment in any manner whatsoever will grant it to the petition. Yes.
What is the
Lordship kindly see the order dated 21/11/24. Your OP number 2 is a police officer.
See service.
OP number 2 is a police officer. I prayed to serve notice through the DG police.
Yes.
Because
so
wherever they are not.
That duly received by the OP2 also.
The notice is sufficient.
On dated 3/4/24, months before last 9 months ago.
Pursuant to the order dated 21/11/2024, the IO of the present case has already served the notice on the opposite party number 2, despite service, non-appeals for
OP number 2.
opposite party number 2.
The
opposite party.
OP2 will last endorsed the receipt last top bottom of the page also.
Yes, the
endorsed we will put
the council for the state has placed on record the written instruction issued by IIC Bodachana PS. Bodachana PS, which indicates that the opposite party number 2 has received the notice. Now leaves the matter for final hearing and the interim order to continue. Interim, let the interim continue.
My lord.
If he is not coming, let's not come. Yes.
You'll also posted to February, March.
45.
27/11/24, my lord. I had some medical emergency. I could not able to present in the court, my lord. The matter was disposed, my lord.
Recall of which order, sir?
27/11/24, my lord.
What was that order?
I was not present, my lord.
No, but passed on that day.
Matter is likely to be settled, my lord.
That will be, I have not passed any judicial order.
Matter is likely to be settled, my lord.
Then you file a fresh one. I'll give that liberty.
My
The petitioner in this application is seeking recall of the order dated 27/11/2024, contending that the parties have settled their dispute. Dispute. I am not inclined to entertain this application. Hence, the same is dismissed. However, dismissal of this application shall not preclude the petitioner to approach this court afresh.
47.
Madam, after just pass over.
Pass over.
48.
May I please? Not the appellant was charged under section 366, 376 by section 4 of the POCSO Act.
I'm waiting for information.
Yes. Reconciliation matter. But he referring to me. But once Chief Justice remark, what to do?
Actually, this is not even
The problem is the actual assignment is of Justice Mahapatra.
No, I am facing with the problem since last 4 to 5 months from like a ping pong, going to that court, this court, that court, this court. But
everybody is happy to hear you.
Nobody is hearing, my lord.
No. That's not, now, in any case, the Honorable Chief Justice has assigned the matter to me. I'll have to hear it. I'll hear.
That's
Yes.
what
Yes. What is this matter?
matter.
Property was not seized from a position.
Are you ready, Mr. Record?
No, sir.
That the property one clock has been seized, which was released on 17/11/2014. That was the instruction. We received it on 29/11/2024. And the accused person has been declared abscond.
Book in the builders. Rabbi Sarma.
You have been absconding.
No, I have already appeared and I have been bail. I filed a causing application before Lordship that I have been implicated after 2 years based on confessional
But
statement.
this report says that you have been absconding.
Rabbi is the. But here, Miller, the interim order is continuing.
That's right, but the report says that you have been absconding.
I will take instruction, Miller. That part I have, because I have obtained bail. So far, the petition is concerned. NBW was
That's
issued.
what the impression.
NBW
last
was
time also I
issued.
got that.
Well,
impression.
NBW is issued and NBW has been stayed. That is, yes, your lordship, if that extent, because NBW was issued against me because what happens, initially case was registered under section 379. Thereafter, my lord, some accused persons were, my lord, apprehended. They, my lord, confessed before the police that I am the person who have received certain stolen property, alleged to have received certain stolen property. So police filed charge sheet showing me as
Now the vehicle is now been given in Jima to one Ram Binod Giri.
yes, they're the owner of the truck.
You just see the
I'll see.
report and get IIC, the IIC which IIC this?
Certified competitive.
IIC, who has given that?
Hirakud.
IIC Hirakud has given furnished a written instruction which is placed on record. Give a photocopy, yeah? Placed on record. Mr. Mishra and counsel for the petitioner seeks an adjournment to get instruction in regard to the aforementioned leave the matter on so also interim order to continue.
You're also interim order to continue. Okay.
Here, there was an extensive argument. Your lordship directed me to produce the agreement copy for your lordship's kind perusal.
Let him be here, then I'll hear.
Yes,
I'm giving a
but,
short.
but I am giving the copy.
You file it in the.
And it's already filed in registry.
While I'll hear it, I'll just see that. Okay. Yes.
Item 63, can it be taken up before launch?
Yes, I
Your
think I
lordship
can
may
reach
fix
that.
up any date in my case.
Yes, date will be fixed. Yes. Yes.
54.
Yes.
In this case, a notice has been issued to open number 2 minute by order dated 4th.
Just see service.
So, but she is not
Sufficient.
54th.
Yes.
But she is not appearing. You can say the order dated 24/4/24. Notice is made sufficient, but she is not appearing.
Yes.
Appeared for a question of the cognizance for the petition on the ground that the petitions are the aunt and uncle of the principal accused. They have been prosecuted under section 376, 294, 506, and 34 IPC and chassis submitted against them. That page, lots of kindly see. That starts from page 16. For Kishore under section 342, 294, 323, 506 by 34 IPC and chassis submitted and cognizance has been taken against the entire accused person, including the petitioner. That is that page, page 26
26.
Yes,
yes.
Out of taking cognizance and the accused persons, namely Chandan, the Bishoy, the principal accused so on so the 342, 294, 323, 506 by 34 IPC against the accused persons, namely Kishore Pradhan, Anita Vishwar, and others.
Yes.
And the petitioners were the 6 numbers in here, they are the uncle and aunt. And then the grandfather and mother, they have been prosecuted under section 376 along with other offences. That is that page.
No, the cognizance is not taken.
Yes.
For offence under 376.
Yes, my lord.
No, just see
the last 2 lines, my lord.
Yes.
The cognizance has been taken under section 376 2 and 342.
So cognizance is taken on so and so. No, but yes, this person named so and so treatment charge.
And despite notice, he is not appearing, my lord.
This cognizance is taken against all of them then?
Yes, my lord.
Charge sheet is filed otherwise.
Yes, my lord.
Yes. Yes.
Yes, Lordship. Lord, Lordship, though the charge sheet has been submitted against all the 6.
What are the materials? Because there is no reasoning given.
Yes, my lord.
Lordship, the up-to-date CD is not available on record, Your Lordship. But as per the charge sheet that has been submitted, this aunt has actually helped The boy and the girl.
But see, in if the charge sheet is filed for these offences,
Yes, Your Lordship.
440, 342, 294, 323, 506, and 34, and the trial court is taking cognizance over and above those offences, 376, 2N.
As a general.
Then some reasoning has to be given.
Yes, Your Lordship.
Why you don't know on what basis? Reasoning is not given.
It has not been.
Then I'll set aside and remand it back.
Lordship, as a Lordship reserved, it may be borne in mind, Your Lordship, that only 70 number of charge sheet witnesses were there in the charge sheet. Out of that, how many have been examined and what those?
Charge has not been framed.
Not found. Cognizance has been taken.
Cognizance. Only he is challenging that part.
Yes, my lord.
Because there is no reasoning.
Yes,
given.
Lord.
Yes, my lord.
There is no reasoning given. Then I'll set aside and send it back.
Yes.
To take fresh cognizance on the, because there is no reason.
Yes.
Admittedly, there has not. It's in general terms. It has been proved.
Yes. The petitioner, by invoking the inherent jurisdiction of this court under section 82 CRPC, has challenged the order dated 2/9/2023 in connection with the GR case number 306 of 2023, whereby the learned JMFC Tilka has taken cognizance of offences under section 376 2N oblique 342 oblique 294 oblique 323 oblique 506 oblique 34 IPC against the present petitioners. Initially, the Initially, the FIR was registered against the against all named
Yes,
FIR.
yes, my lord. Named FIR.
Against the present accused persons, along with the principal accused Chandan Bishai for alleged commission of offence under section 376 2N or 294, 323, 506, and 34 IPC. However, after investigation of the case, the police filed it charge sheet number 150 of 23 dated 21/7/2023. Elise 23 filed the charge sheet for against the principal accused for offences punishable under section 376 2N. Read with section 342, 294, 323, 506, 34 IPC. Insofar as the present petitions are concerned, the offence under section 376 2N, since no offence under section 376 2N is made out, the police prepared not to file charge sheet against these petitioners for the said offence. However, for other offences, namely 342, 294, 323, 506, and 34 IPC, charge sheet has been filed against them. The trial court, by the impugn order, has taken cognizance of cognizance of all the offences against the petitioner as well as the principal accused. Mr. Principal accused. Mr. Rautra, when counsel for the petitioner submits that if the trial court takes cognizance, has taken cognizance of offence under section 376 2N against the present petitioner, despite the fact that the charge sheet has not filed for the said offence, the reasoning for sufficient reason should have been given. Should have been given for taking cognizance of the said offence. However, very mechanically, the trial court has taken cognizance of the said offence against the present petitioners without assigning any reasons or discussing any material on the basis form part of the charge sheet on the basis of which the cognizance has been taken. I have perused the charge sheet. and the documents form part of the charge sheet, and also analyze and also peruse the MP note. I am for the considered view that Mr. Rautai is correct in his submission that if the charge sheet is not filed for a particular offense by the police, and despite that the trial court takes cognizance of certain offense, reasoning is should have been given.
Second.
Trial court, by the trial court while taking cognizance of the offense. In the absence of appropriate reasoning and appropriate reasoning given by the court below, the cognizance order is not sustainable, Hence, I set aside the impugn order and remit back the matter to the trial court to consider the charge sheet and by considering the charge sheet and take pass a cognizance order, detailed cognizance order with appropriate reason. With this observation, the petition is disposed of. Yes.
Your Lordship, I am on behalf of Mr. Das. Your Lordship, due to some personal inconvenience, my senior couldn't appear. If this matter could be adjourned post 3 weeks.
Next.
86. Your Lordship, I humbly pray there is one counsel from outside going to appear. If at your Lordship convenience, it could be posted on 31st of Jan or 3rd of February.
He will give according to the available.
But here this I am for the petitioner, my lord. The more question has to be more question is, my lord, without impeding the company as a party, they have filed the complaint case and the managing director as a party.
I'm for the complainant.
He is appearing for the complaint.
My lord, before your Lordship, my lord, kindly have a glance.
I have filed some other.
Earlier, my lord, he has twice. It is a 1cc case of 2009. Earlier, he filed an application in 1cc case number.
That has not been reflected.
3618 of 2011. That is disposed of in on 23rd February 2012. Again, he filed an application for quashing of the criminal proceeding. Again, that criminal proceeding that is also dismissed. He obtained stay order. Subsequently, did not appear. In 2020, it was disposed of. That is a criminal proceeding. He is coming.
Disclose about this.
No, he has not disclosed.
My lord.
So how much criminal proceeding will be one?
1 minute. What is? Yes.
My lord, the more question is there without impeding the company.
Have you disclosed your
pardon me, lord. I have not disclosed as because I have also filed the application for CLMC challenging the imbue order. I have also filed. But as far as other cases concerned, they are beyond my knowledge, my lord.
What he did, my lord.
Supreme Court, my lord.
Why the knowledge submission?
Put it after 3 weeks.
My lord, he is obtained by misleading the court. My lord,
I am not habituated of listening to lawyers at a time. That's the problem. I'll develop that practice.
No, that is.
I think within 3 weeks I'll develop that practice. Simultaneously, I can hear you, both of you. After 3 weeks.
That is, my lord. I want to brought.
If somebody is saying something in this petition, please have patience. I know, I understand it that he has already earlier approached this court, he has not disclosed.
My lord.
Twice, thrice he has approached, whatever. But what he's saying, just see his petition. Yes.
My lord. My lord, have a glance to page 16, my lord.
Now you just overcome that preliminary objection. Why have you not done it?
My lord, I may be excuse my lord, pardon, my lord. These matters are not within my knowledge.
So, for the same cause, have you approached this court, which has been dismissed?
Well, I will verify, my lord. I have not verified.
Then I can't entertain, because once a coordinate bench has taken a view, right, wrong, whatever, I can't review that.
No, my lord.
That's what that.
I have challenged the imbue order.
No. Where is that order?
This question of the criminal order of cognizance.
Cognizance order, you have challenged that.
Well, I'll bet.
Just see.
Well, as per the judgment of the
prior to the quash the order of cognizance dated so and so, passed by so and so.
My lord.
He's telling that.
My lord, I'll verify, my lord.
No, verify what this.
My lord.
Will you verify the court order?
My lord.
You have to disclose. On that.
My lord, once I have filed an application for whatever, this is not a bar to file another application before this honorable court.
No, cognizance order you have challenged.
My lord, I have
The
challenged.
court has dismissed it. You can't file it.
Dismissed for non-prosecution, my lord.
No.
What he is
Yes.
stating.
Yes, non-prosecution.
My lord.
Stay order, then he did not appear for 8 years. Then
I dismissed non-prosecution, my lord. But the matter has not been decided on merit. And on the point of law, that has not been decided, my lord. My sole question is
Revive that order. Revive that proceeding. Revive that proceeding which has been dismissed for non-prosecution. You can't keep on in the 138 matter. You can't keep on approaching. See, 2012 this matter is pending. You have been coming every third day, some petition or the other. You don't disclose it also. And see, 138 proceeding should have been concluded within 6 months.
15 years.
My lord. My lord, later
15 years.
My lord, later direction be given to the lower court to disclose the
Why should I do that?
My lord, the company is not an impudent party, my lord. This is
Maybe-
the only question that which has been decided already by this honorable court, my lord.
15 years back, the law was different.
My lord, different. Correct.
And
Exactly.
you successfully dragged the matter for 15 years. Today you are trying to take advantage of that.
I have not done, my lord.
Yes, of course. You file a petition, got a stay, and the stay continue for from 2012 to 2022. Thereafter, you didn't appear. It got dismissed in default. Now the regime has changed. Now you file another petition. What is this? You can't misuse the court process like this. On that ground, I'll dismiss. Madam, petitioner had earlier approached this court by filing CRLMC number 1032 of 2022.
My lord, I will produce a judgment, my lord.
The order dated 16/4/2009, passed by letter STGM Talcher in ICC case number 18 of 2009, whereby cognizance of offence punishable under section 138 NI Act has been taken against him. The matter was pending from 2012 up till 2022. The petitioner had obtained.
My lord, I may permit to withdraw the application, my lord.
Yeah, for the further.
With the liberty to
Eventually on 22/3/2022, none appeared for the petitioner, as a result of which the CRLMC 1032 of 2012 has been dismissed for non-prosecution. The petitioner has item number. This is 50. Yes. Petitioner has now approached this court by filing the present criminal MC on various grounds, including the ground as has been urged by him in the earlier round of litigation. In this state petition, he has not even disclosed regarding the earlier proceeding he has resorted to. The counsel for the opposite party at the outset has taken the shown this court the proceeding dated 22/3/2022 past 22 in CRLMC number 1032 of 422. The petitioner is successfully dragged when the complaint was filed
2009, 18 of 2009.
The proceeding under section 138 NI Act was initiated in the year 2009, and the petitioner could successfully drag the matter for about how many years now?
15 years.
15 years. 15 years. Therefore, I am not because of the conduct of the petitioner. I am not inclined to entertain the present petition, particularly for the reasons that the section particular for the reason that section 143(2), I think 143(2) or 3, 143(2) or 3 देखो for NI Act ordained statutorily ordained to conclude the trial of a case under 148 NI Act within a period of 6 months. However, the interested petitioner could successfully drag the complete case for about 15 years. Hence, no interpretation is called for accordingly.
I may submit to withdraw my application to refer my prayer.
I pass the order.
Hello.
Yes, next.
Sir. First, you kindly see the order dated 13/24.
Yes.
Well, here in self-same issue, a civil suit was filed by the informant and it was attended.
Yes.
It was attended finality on the
Notice what is the position? Sufficient.
substance also.
Yes.
In self-same issue, a suit was filed also. It was the matter was settled between the parties, and the bank has got entire amount. It is a page 15 lots.
It's the informant is a bank.
Yes, madam. In
Bank
parallel
why-
procedure.
why the bank-
ପଇସା ପାଇଯାଇଛନ୍ତି ତମେ ଆସୁନା yes
Service through the IO.
page 30 lots.
Sir, through the IO, interim order to continue. Yes.
Right. 28. May I pray, let's be another, I have filed an IA. And while granting bail, the petitioner was asked to deposit 3 lakhs, my lord. He has deposited. In the meantime, entire amount he has deposited before the bank and matter has been settled. NOC was issued in favor of the petitioner.
What do you want?
I want that my 3 lakhs which was deposited as security that may be returned.
Wait, let them talk.
Because my lord, he has by availing some handloom, he has settled the issue.
I'll give a short date. Let the bank be served through the IIC of the concerned police station. Okay. Yes.
58.
130 meter lordship, last university already had this meter lordship. An order has been dictated. My learned counsel appearing for the petitioner takes time on the grounds to verify the judgment, whether the second legal notice is maintainable lordship or not. That effect, that case is in adjournment for today, lordship.
Yes.
And as it Nahanti, as Mr. Acharya is appearing in this for a petitioner.
Yes.
Pass over for the after
Pass over, let us
yes, sir.
pass.
Yes, sir.
59.
Yes. 59. What is it?
376 in there. The petitioner filed a petitioner was compromise.
Compromise.
Victim and the petitioner now residing in one mess.
None of them are there. Let's see, pass over.
60.
60 minutes, Lord. Okay. Lord, in this case, Lord, petitioner seeking release of his vehicle in Jimma, my Lord. But the seeking Jimma of the vehicle, my Lord, which is implicated on the under NDPS Act, my Lord.
Yes.
And just have a glance the page 14, my Lord.
14.
Page 14, my Lord.
Yes.
Last line, my Lord. According liberty given to the prosecution investigation.
Last line of 14.
14, my Lord.
Page 14, 1 5.
Page 14.
Accordingly, give
Yes, my Lord.
giving liberty to the prosecution investigation.
That lower court hold that only prosecution agency is the empowered for file the 52A application, my Lord. But while consideration same case, my Lord, Lordship has this is Lordship's order. In another case, my Lord. Lordship hold that in para 4, my Lord. However, the present petitioner is seeking release of the vehicle on Zimanama with certain condition as may be deemed fit and proper. Therefore, the court below has inappropriately applied the ratio the said judgment of the present case, my Lord.
Yes.
That is the case of Koraput and Koraput SDGM, and this is the case of Jaipur SDGM.
And there is a recent judgment also.
Again.
2 days back.
It Supreme Court may be there.
2 days back.
Yes, yes, Lord.
Order
This one.
Interim Jima, you have to give it.
1 mile.
Yes.
Obliged.
Lay the order.
61.
The case where the fraudster have taken my money where she put on hold in the account. Annexure 4, my lord, kindly see page.
Service.
Lords, may kindly turn to page 33.
Who is appearing for?
I'm for the bank.
You are appearing. Okay.
The state was directed to obtain. Kindly see, my lord, annexure 4, page 33. Where the report was filed by the IEC police. And where it is, my lord, kindly I am permitted to read 33, page 33.
33.
Yes.
Yes. Yes.
It is before to the, my lord, sub-regional magistrate memo number so respected sir. With reference to the case subject cited, I am submitting here that the money is neither seized nor necessary for the purpose of investigation. The cash of rupees 9,90,000 is freezed by the BM ICICI Noida branch on 7th of June 2024 on our requisition. The fraudster had taken 15 lakhs from the complainant, petitioner account.
You are the complainant.
Yes, I'm the complainant and the petitioner.
Yes,
and the fraudster had taken 15 lakhs from the complainant account. As per the acknowledgement, wide number so-and-so, CIDCB, help desk number 1930, money of rupees 4,93,510, 4,17,000 and 76,000 of complainant account had put on hold on a requisition. The said amount have been freezed by the ICICI Bank. Hence, the freeze money is not necessary for the purpose of investigation. So, my humble prayer, this instruction.
What do you say?
I have no objection. If the Lordship direct or the authorities say to defreeze, we'll defreeze. I'm the bank.
You are the bank.
I'm the bank. I'm following.
This is the IIC's report.
IIC, they asked us to freeze it. So we put on hold.
What do you say, madam?
Because of the fraud, my lordship, the IIC told them to freeze the account. Now, my lordship, it was clear that the account has been in the account statement we have seen, my lordship. The account statement reveals that, my lordship, fraudulently they have.
Where is the impugn order?
Your kindly annexure 1, London SDM, in the corporation petition, the lordship, can you see page 19, annexure 1.
You have a complainant, huh?
I'm the complainant.
What is the reasoning given?
Reasoning is in last 22. That there is nowhere is found that the present opposite party number 2 has freezed. The bank has not freezed, the SDGM said. And everyone as stated petition. The branch manager ICICI Bank Noida branch has also not stated a single regarding freezed. So these are all wrong assumption, presumption.
Then I'll record the consent of both. Petition is agreed by the order dated 27 or 28.
That is 28th of August.
28th of 2024, whereas his application under section 457 CRPC for defreezing for his account number so-and-so page 19 so-and-so has been turned down. The Learned Trial Court, while turning for the reasons stated as under para page 21, para 2, restricted as under rejected the application. Rejected the application. Take the name so and so appears for the name. Mr. Mishra and Counsel for the petitioner has taken me to the annexure 4, whereby the IIC of which police station is IIC? Nagar police station has furnished has submitted before the subordinate judicial magistrate by its instruction dated 26/6/2024 in stating as under stating particular page 33 Mr. Marana appealing for this submits that he stands by, he has already obtained instruction and reiterates the same stand as has been mentioned in the written instruction for this by the IIC dated 26/6/2024. So appears for the bank and permits that if the order is submits that he has no objection in defreezing the account. Regard being had to be submitted by the parties the bar, I'm inclined to allow the petition. the bank, what is this? The account number so after the petitioner maintained in ICICI Bank, Nagar Bank, is directed to be free, subject to the petitioner filing, submitting a indemnity warrant before the court below, or to the extent of 9,93,000 010, 9,93,0, 10 lakhs per 10 lakhs. Indemnity warrant to the extent of 10 lakhs. We file an indemnity warrant.
Not particular in this case, your lordship may.
What is wrong in filing indemnity warrant? If something happens, at least
Yes,
you can indemnify.
yes.
Yes. Indemnity before the court below, as well as before the bank. Bank also he let him file indemnity. Both. Yes.
I am appearing in criminal mistakes number 4665 of 2024, whereas now. Last week, I have a transfer order dated 18/12/2024, because I have some preliminary issue to be raised. 18/12/2024, you have access order.
Yes.
I did not get the entire order, but you asked me turn to after recording the argument advanced by John Counsel and including the senior counsel, you must have turn to paragraph 12.
Paragraph 12.
Yes.
Yes.
Page 16. No, page 16. Of course, I have obtained the copy of the order. Paragraph 12. Because counsel have taken, counsels have taken me to the voluminous record placed before the court to witness this court that Canada's case is made out against the petitioner in the face of the complicated facts of the case investigation by the police is immediate. Taking note of the appointments and submissions, this court takes a question and sought information from one state council regarding the progress of the investigation. Mr. General and Additional Government Advocate of the state have placed on record the instruction dated so-and-so issued by Mr. A.K. Mishra, dated so-and-so, Bhubaneswar, paragraph 2 to indicate the said instruction as still relevant for this present purpose. That the prosecution case is unfairly, let's keep over. Because that state may come to paragraph 15, internal page 19. During hearing, it has also been brought to the notice of this court that one of the accused in the present case, namely, Smriti Ranjan Panda had applied for anticipatory bail by filing an ABL application under so-and-so.
Yes.
The coordinate bench of this court had ordered it at 16/12/2024 and allowed the application of the same to namely Smriti Ranjan Panda and extended the concession of the plea as bail to him by noting the fact that the present batch of petitions are pending before this court. It is no gain observing that the petition can also be sought to the recourse as has been obtained by the co-accused namely Smriti Ranjan Panda. Having said that, I am of the considered view that in the fact scenario of the present case, this court at this stage shall not venture into the merit of the case, rather leave it to the investigating agency to investigate the entire allegation from the right perspective. Since the entire case sought to be projected by the complainant of the opinion number 3 hinges upon the document and large part of those documents have already been placed on record in the present proceeding, it would be appropriate that the investigating officer, IU, shall look into each and every document placed before this court and deal with the same in accordance with law by preparing the report final form under section 173 CRPC, section 193 of PNSS. Then taking into consideration the entire conspicuous of the case at law occupying the field, I am the considered view that the petitioner need to be protected intermediately till they restore to the right remedy available to them under law, as has been availed by the co-accused, namely Smriti Ranjan Panda. Hence, the IO of the present case is directed not to take coercive action against the petitioner, subject to the petitioner extending cooperation to the investigating officer to facilitate the fair investigation of the case. The petitioner at liberty to avail the procedural remedy of pre-arrest concession from the competent court. Till then, the protection granted by this court shall operate. Now, I am speaking next. Mr. General and Additional Government Advocate will state is directed to file a press status report by the next order. All the parties. Now, the stage of the investigation.
So what is the objection to this? I was carefully hearing you. When you find some fault.
We need to understand if your lordship's not.
I try to validate. The idea is. I was carefully.
My purpose of placing this order query is, since your lordship have passed this order, now investigation is going on. So at this stage, no further order is required to be followed. Matter is presented for hearing.
My lord, may I just say this? May I just say this? Since a lot of this trouble is invited by me, I must make clear. Perhaps because I was on VC, it was not made clear. Not on the last occasion, the issue was whether this matter is to be heard finally. On after hearing us, your lordship had kept it for being heard. There was an interim arrangement that's in place. Fine. Today we are here to address your lordship. It's a matter short issue where we will show to you on their admitted documents on the FIR. It's an abuse of process. Here is a litigant who plays hot and cold with the court, who plays hide and seek, who's a person who takes a stand before the NCLT and now wants to renege from that stand. That's the sum total of the case. And if that is the sum total of the case, it's an abuse of process. It ought not to be entertained or not to be allowed to continue. That's the short issue. His highest claim is
your entire case is exception 7 of Bhajan Law. That's your entire case.
4 and 7.
And I just want to know what these people are doing. The investigating, let us understand what they are doing. I have protected you people.
Yes, of course.
There is no problem in that.
Not my lord, we find out what they're doing. I'm given to understand they've earlier filed one report already.
I'll see what my proposition is,
Yes.
subject to what you people say. I'll continue this order. Awaiting the
one thing I
report. Let the report come. We'll see what is happening.
I must inform your lordships about one development. One development I must inform. What happens is this, your lordships say, your lordships want a report from the investigating agency. The investigating agency sends a notice, today we are on 9th, sends a notice on 7th to a person who is not a resident of the state, say come on 8th. Why? Because we are at the eve of the hearing. So unfortunately, what is happening is this: the complainant today has filed its response.
They want to make out a case of non-cooperation.
I can't put it better. I can't put it better than the fact that a situation where the notice comes on the eve. No, somebody is
Yes, Mr.
My lord, dear lordship.
See, these are all documentary evidence. You don't need 161 statement to be recorded.
My lord, there is a volume of documents, my lord.
Yes.
I have talked with the IO. And he has stated that some of the petitioners have supplied some documents that is under scrutiny, my lord. Apart from that, your lordship, this is only 9, and your lordship has directed 2-3 weeks back, my lord. Apart from that, my lord, investigation is a very preliminary stage. So if your lordship will allow some time, that we can.
No, that definitely we will allow, but the fact remains that
we have not arrested, my lord. As per your lordship's direction, we have not
under the garb of this order, you can't keep on calling them. You have to scrutinize the documents and arrive at a conclusion.
My lord, unless they come, my lord, how the IO will record the 161 statement, my lord?
First, you analyze the document.
I asked myself,
I have analyzed the document. I need not express anything.
The genesis of that document, my lord, how he will ascertain.
Who do you want? You tell me so that I can ask them.
Can I make
your lordship keep it some other day? I will give the
may I just make good one submission, lord? The issue is now limited to 2 issues and 2 aspects. The stand of the first informant in the NCLT, which record is available A with the third respondent and B with the NCLT. Please ask them if they've even gone and got the copies from the NCLT or they verified that. There is no answer on that. That's the problem. They should just verify that record the moment there is.
Do you people have the certified copy of the
NCLT? He placed on record. They have to just verify it, not that's all. If that stand is recorded, not saying
the certified copy of NCLT proceeding is there.
Your lordship is also directed to serve a hard copy. Nobody has served this hard copy, my lord. No doubt that is a verbal order.
See, logistic issues, I don't think I could go into all. Yes.
Page 11 of the lordship.
Yes.
My lord, hard copies were served. Not if my learned friend wants. But I tell you,
these are the issues. I don't think I don't know. Give the hard copy now. Give the hard copy right. The entire hard copy.
Fresh copy. Not I'll give it.
And in my presence, give it to him. So that we can sort out
one small indulgence. I
think the fair would be the interim, let the interim continue. They proceed, let them file a status report. I am assuring you, the moment the status report comes, I'll go into it. Whether the case is made out or not, I'll just see.
Small request, Your lordships have rightly said, in my humble submission, They have to analyze the documents. After that, if they have any questions for us, let them ask us those questions. But today, the only purpose is
The problem, Mr. Agarwal, the problem is neither you nor me can guide the IO. It's the prerogative of the IO. I can't, I can just orally we can tell, but by way of judicial order, I can't guide them how to proceed. That's the problem. Yes. It is not a very complicated case, but for presence of all big luminaries, this has become complicated. It is a very simple case.
But fortunately, we've come here. Not fortunately, we've come to a place where there is some sunlight. In Delhi, there is
Go have Jagannath Darshan and go today. I will continue this.
Then there is a complete night.
Yes.
Lordship may maintain this interim order. Call it after 3 weeks. Let them file a status report and then we will examine where.
But I'll only suggest, Mr. Jagannath, don't keep calling people and. This is a prima facie view. I'm not expressing any opinion. I got an impression. The complaint is being filed. It is an arm twisting kind of technique.
Exactly.
So you by calling these people, you are you know
Unless and until,
please don't do that. Please don't do that. And please analyze the document, find out whether a case is made out, then we will see after 3 weeks. Please let the
your lordship may kindly have it. For a moment, your lordship may. Direction.
Madam, please supplied a copy. I supplied another physical copy being given today.
I'll just record that. I'll just record
Ensure that the entire India is here.
That's the reason I'm saying that it may not turn out to be a arm twisting litigation, you know.
My lord,
Please be careful about it.
My lord, if I will tell my IO that you should not call them, my lord, then it will amount.
I'm not saying that. I'm not saying that, but you know what to do.
My lord, I understand.
Neither I told you neither none of us can advise IO. IO is the prerogative of IO.
We are not advising the IO, but IO might be being advised by something else.
That's right. That's nobody can.
My cases are totally separate from these other people, Malas. I don't know allegations of forgery and other things have been made against them. I have nothing to say about it.
But your name is repeatedly taken by the.
Making a board assertion, can a case be made? Nothing has been.
Before Lordship,
to begin, I'm just saying. To begin with, you analyze the document supplied by them and file it status.
There is
There's
one fresh matter also on your Lordship's board today. Same order.
Same order. Right.
That's 91 of 25.
Pursuant to the order dated last order, dated
18th of December.
18th also. Mr. U.C. Jenna has not obtained the status of the investigation. On the contrary, he submits that the documents form part of the petitions. The voluminous document part of the petitions has not been, hard copy of the same has not been supplied to him. In response to the same, the instructing counsel of Mr. Agarwal and Mr. Luthra in the court has supplied the hard copy of the entire documents to Mr. Jen.
Sierra Leone's petition.
Sierra Leone and document.
And with the Alexa,
Jenna submits that he would be passing on document to the investigating officer who shall analyze the document and file a status report by next date or so. Only analyze the document, file a status report.
And not let the status report be supplied to us in advance so we can assist. Let the report be supplied to us so we can assist your lordship. I don't know the practice of
let it come. Yes. See, because it is again supplying case diary kind of treatment. I don't want to use it. Again, that objection will come.
Lordship said that only analyze the document. That way about interfering in the
Investigation, my lord.
That is not interference.
This is a ridiculous submission.
What is interference about it? I am only saying that analyze the documents. That's all. Because this is a commercial transaction, pure and simple commerce.
Ridiculous submission.
No, I'm not saying that. Can you say that? No. I am not. You tell me one thing. I can understand if that objection is taken by Mr. Jana. Why are you interested? Why are you interested that they should be there? Let Ms. Jana say that I can take care of that.
My lord, I have already told.
That is the reason I am saying that it is armed proceedings. That is the impression you people are giving. So please hold on. Let the Mr. Jana says you do have any objection. I will verify.
My lord, your lordship, if necessary, they can call particularly.
Have I injuncted you?
My lord,
I will only say that analyze the document which they have given. That's all.
My lord, after analyzing that, my lord, first instance, he has already given the status report and he has found.
Just see your status report. You have only reproduced the complaint.
In the first instance,
status report. What status? See the kind of litigation is there. And what kind of application of mine? Only you reproduce the complaint and gave it.
If that is no privacy is not there, you will find the.
What could be said about this? So please analyze it and.
If your lordship just a single word, your lordship may kindly add that if necessary, the IO can call.
Why should I guide
the IO?
Why should I guide the IO what to do, what not to do?
Because
I am only saying that analyze the document which is given. Over and whatever. Have I said that don't call?
They have a date in February.
My lord, I have just one small. My lord, can I just make one small request? But there's one.
Suppose while analyzing a document, you need somebody's presence. Why should I say that? Why should the court say that? I don't understand.
One small issue. One small issue.
Suppose a signature is there. He has to call your signature not. Will you ask or not? That is the analysis. What else? What else?
What you want is not what court will direct.
Just one small issue.
Yes.
I think respondent number 3 is well represented, and I'm sure, but there is unfortunately a lot of press reporting which happens about construing the.
No gag order for.
No, I'm not saying on the gag order, Lord. All I'm saying is about some restraint rather than every time, Lord.
This guy again tantamount to gag order.
But the story is being repeated. I leave it to your lordship. We are not.
That will strengthen the impression gathered by the court.
In the new.
If this kind of press report comes, then that will strengthen the impression which I have gathered.
But coincidentally, it happens a few
times. I have given the indication.
We place it on record.
If it comes in the press, then the impression gathered by this court is strengthened. Please don't do that. This is not such a huge fraud or something. It's a matter of 11 crores. And I tell you, by the end of this litigation, and both the sides would be spending more than 11 lakhs. More than 11. So therefore,
when would you
come out with the proposal, they will accept it. You come out with the proposal. Now you give a proposal, I will put to them and finish it up here right now. Come with the proposal.
Entire case is a denial of the commitment.
No, you come with the proposal. Mr. Parija can lead and get some proposal from your side.
Yes.
I'll put it to them and finish it up.
Yes. Not today.
Not today. Give a proposal. Give a proposal. Yes.
My lord, when would your lordship like to keep it for?
After 2 weeks.
After 3 weeks.
Yes, Mr. 3 weeks. 3 weeks.
To my learned friends, convenience.
12th February.
I'm not sorry.
12th February.
12th February.
And tell your IO if he wants anybody's presence. Who is IO? First, see, this is a case of all documentary evidence. You may analyze. We are not advising. None of us are advising. But whenever you are giving notice to someone, give sufficient notice so that at least not that to give notice and come tomorrow and Yes. But I am not saying that you give notice, huh? Okay, then 14th. 14th will shoot.
But then instead of not 14, then maybe some should. Would your lordship then not have it after 2 weeks on 28th, not perhaps? February 28th, I said. 28th.
28th. And meanwhile, it is open for the parties to explore a possibility of settlement. I have indicated that.
One small request. In the new matter, in the fresh matter,
I'll be with you.
they can also file a response. The complainant, the respondent number 3 can also file.
Very,
This is 91 of 25.
And interim order passed in the corrected matter dated so is also applicable.
I'm obliged. I'm obliged.
Seven, my lord. March is 7, my lord.
Not have it in February. Let's not delay it so much because people are. Sir.
24th February.
There may be some challenge. But then in that event, just
one day you.
Not just give me a moment.
24th, 25th.
No, not then have.
Let it be 21st February.
Not
21st February.
21st is Friday.
25th.
Not 21st. I have some, not 21st to 23rd. There is some memorial event in my father's memory. I will not be able to come. That's why I'm saying, not if your lordship may consider not otherwise. 14th.
You invite all of them. Everybody will be there. Nobody will.
At least Mr. Parija knows he gets an invite every year. 14th. 14th, not have it 14th.
May I pray one thing?
14th.
I may pray one thing, my lord. One hard copy I have received. So the 3-4 matters are there. So can I pray? In all matters they can provide because they are relying some other documents are there also.
Please supply the copies of all the. And I have recorded that meanwhile the parties can explore the possibility of a settlement. Possibility of it.
I'm most.
If it happens. Okay.
Deeply obliged. Interim order.
Interim order to continue. Sorted. Yes.
Item 1.
May
Procedural.
Yes.
Time for the petitioner.
Yes.
Proceed. The dispute arise for the land.
Item 1, my lord. They're supplying me copy that we have settled that. For the alleged offense of the case of the year 2014, provided this case also has to be settled. And the alleged one of the alleged offenses 436 and 326. But one of the accuses come. Your lordships always all the accuses.
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 Yes.
There are 11 accused.
11 accused. Everybody has to come. Accused have to come. And what is the stage of the trial?
That also
What is the stage of the trial? 2014 case.
Charge sheet was filed in 2018.
So therefore, if it is in the fake end of the trial, I can't.
Trial yet not been started.
Where have you said that?
That is in the order sheet.
Where is that? Obviously, when the charge is framed, obviously that day. Where is that order? Where is the order? Which order you are talking about? In any case, nobody is there. If we are not going to state to seek to file a status report regarding the trial, regarding progress of trial, progress of trial, please the matter after 2 weeks. Yes.
My letter,
Yes. Let him get the status. Yes. Is nothing there, you have not filed anything, no accused is there. What can I do? I can't cause like this. Accused person has to be there. Get the status report, we'll see. Yes, next. 4.
Item 4.
oh, bless.
And let's say date must be fixed.
No, date will be fixed. Yes, next. 4.
Okay.
Yes, 4. It is apparent that there is no confiscation proceedings initiated yet. Therefore, counsel for the petitioner speaks and therefore the vehicle. Okay.
But I from in that case, my lord, the accused is not, the owner was not the accused. The accused was released. But in paragraph, another thing, lordship because it was not 725, their judgment, your lordship, is in the NDPS Act, there is no bar for any implementation of the issue. In 2025, there is a judgment, and I have got that judgment. In that case, my lord, I have not gone through an entire judgment, but I have found that in that case, he was not an accused. For that reason,
No, nobody is there, simply urgent.
But before trial, after trial, confiscation can be made. So we have to sort it out. Sorry.
Okay. Yes.
33.
May I please, your lordship?
Yes.
So, lordship, the main allegation in this case is 493 of the IPC, your lordship. Here, the complaint is a married lady of 33 years of age, and she kept extramarital relationship with this who is 30 years of unmarried.
Custody since?
Custody since 31/3/2024.
Okay.
And the charge sheet submitted on 24/5/2024.
Yes, madam.
And this
Yes, my lordship, 162 statement is there, my lordship. She can see says that they have the relationship between them, and he promised her to marriage, but he denied. And my lordship, another thing is that when the investigation going on, she tried to commit suicide, and for that,
She tried to commit.
yes,
Yes.
306 is also there, my lordship. That's all.
What are the charge sheet? Where is the charge sheet? What are the charges?
Yes.
charge sheet I have filed, your lordship. Kindly have a glance. Only 506 added to the all other allegations, your lordship. And this case is squarely covered.
Show me
your lordship.
164. Show me 164.
My lordship.
And they have a relationship for a long 1 year. And squarely covered by your lordship decision.
Where is the charge sheet? Where is the charge sheet?
Lordship charge sheet I have filed.
Page?
Page 25 onwards, your lordship.
25 hours. Then
164 statement is there.
25 onwards. Let's see. 20?
25, Annex 5 series, your lordship.
Annexure 5.
Annexure
Yes,
5.
Lordship, there are 2 ingredients that are missing.
Okay.
There is no cohabitation.
I think it's entirely to be.
Yes.
Right.
Yes.
It's not relating to property. Allegation of the petition conflict. During investigation, the statement of the victim has been recorded after section 154 CRPC. C in her statement has entirely stated that she has been in relationship with the petitioner, and on the pretext of marriage, the petitioner has committed sexual into course with her many times, and subsequently it's the result out of his promise to marry her. After investigation, charge sheet in the present case has already been filed on 24/5/2024 for alleged commission of offence under section 417 oblique 493 oblique 506 oblique 2924 IPC. IPC. It has taken you 164 for in 164 in precise the victim has in her statement under 164 has stated evidence. Okay. Petition is in custody from 31/3/2022.
24 years.
24 years. Regarding head to the nature of allegation and the period of custody of the petitioner is entitled to grant of bail. Particularly the allegations, particularly where the charge sheet has already been filed. And how many witnesses are there?
7.
There is
Trial has
7.
Yes, granted. Yes. Yes. Yes, 47. Yes.
Noting is was it part number 4 and 5?
4 and 5.
4 and 5.
Yes.
Return on, sir.
No, service is not complete.
I am appearing for 6 and 7. They are actually not the contesting parties.
Okay. Who is for petitioner?
Well, I am for the petitioner.
Okay. Service is not complete.
I'll press requisites.
They are not the contesting parties. And
But if they are implemented as a party, then notices go.
Within 2 days, 3 by Monday. I'll file.
Opposite but no 2 and 3.
4 and 5 also return on delivery.
Service on respondent number 2 to 5.
ground type of- ground type
2
of-
to 5 is not complete. The petition take first step.
Let him take steps by both ways. By both ways, special messenger.
Special messenger you will take. Is
Out
reluctant.
of town.
Takes through special messenger also. Take. Okay. Yes.
58.
This is your last university matter hard link. If the 130 NI direct matter process, I am acting from the opposite party complainant. And at the last date, your lordship, the Warrant Counsel accused the prisoner 6 times to come with a judgment that the dual legal notice is not maintainable, your lordship.
Yes. Who is appearing?
Mr. M. Manoranjan Acharya, your lordship. Order to be dictated, your lordship, in that part. your lordship.
Already dictated the order.
Yes, your lordship.
Okay. Order. Reserve code. I have already dictated the order. Last date. CMG shall not in time to. What reserve? I have already given dictation. Dictation nahi achi, the order achi thi. Order achi 3/1/2025 order pass hui telling the matter was taken up for hearing on 3/1/2025 and following order was passed. The counsel for the petitioner had sought time to address the court to address the court on further issue. Address the court on the to cite the judgment on limitation. On limitation. However, when the matter was taken up today, even on the second call, none appears for the petition. Therefore, the petition is disposed of in terms of the order passed on 23/1/2025 25 according to the petition.
And interim order passed earlier, self-vacated.
Obviously.
59.
My lord, item number 59 on behalf of Mr. Origin, on behalf of Mr. Origin, kindly adjourn this matter. He is suffering from fever. Mobilized.
In the land acquisition proceeding, the petitioner was noticed. He appeared before the authorities and on production of the documents, an award was passed. And the amount was released on execution of an indemnity bond with the condition that if any dispute arises, he will deposit the entire money. After about 2 years, again notice was issued on me that you are not the person who is entitled for amount, kindly deposit it. I deposited the entire amount. The entire amount is in the government treasury, madam. The vigilance has registered a case that is being challenged. I have filed an application for discharge that having been rejected, I have come up here. The last occasion, your lordship put me a question. In the impugned order, there are 4 persons. Your lordship may kindly come to 4 persons are there. One Sushant Kumar Swami, your lordship at page annexure 2.
Yes, Ravindra Lenka, Arun Manti.
At this stage, your lordship may kindly come to the last order. Order dated 10/9/2024.
10/9?
10/9/2024. Last order.
Oh, yes, 10/9/2024. Yes.
Sushant Kumar Swami, Ravindra Kumar Lenka have been already abated by the order dated so and so, so and so. They are dead. That is why.
Out of 2 accused person. Now the accused Arun Kumar Chaudhary and Nushin Chaudhary.
Arun Kumar Chaudhary is a mistake. Arun Kumar Mahanti.
Oh, okay.
Petitioner. And Nrsimha Charan Swami. So far, Nrsimha Charan Swami is gone. That is item serial number 4. Charge sheet. Your lordship may kindly refer to the charge sheet.
Yes.
I filed charge sheet.
Yes.
Sanction was refused by the government. Accordingly, charge sheet could not be filed. However, the trial court took the cognizance that is a separate issue.
Yes, I will.
But what? My humble submission that.
So out of 4 accused, 2 accused have died. Trial is awaited. And 1 accused.
Myself is 1 accused, and the other one is against which.
Sanction is not there.
Sanction was not there.
But what cognizance is taken, the trial is going on.
Yes, yes. No, trial has not commenced.
Okay. Cognizance is taken, he has not challenged that.
That I cannot say.
Has he challenged that?
No, perhaps not.
Anyway, okay.
So my humble submission is that, or pursuant to the notice of the authorities, I appeared, and the award was passed in my favor, and I accepted the money on the execution of the bond.
Where is that? Where will I get?
Kindly see that.
Lordship permits, my lord. Let us shortcut the matters, my lord.
No, just a minute. Why this anomaly arose? Arun Kumar Mahanti, there are 2 Arun Kumar Mahantis. Arun Kumar Mahanti name, father's name, age and address are identical. Had there been any dissimilarity in one point, this would not have happened.
But you knew that he is not, your land is not.
How can I know?
Your land is not required.
Yes, I produced the document. On scrutiny, it was.
Whether your land is acquired?
No. My land was not acquired.
Then why have you taken the money?
I'm explaining, my lord. I was noticed, my lord. Land acquisition officer noticed me.
Noticed you because of the name.
I produced the document, my lord. On verification of the document, it was award was passed, my lord. I didn't know that such a land is not existing because I was all through at Bangalore in the hall. I was serving in the.
You tell me whether you own any land.
Presently,
you sought to be acquired.
No.
Then why have you taken the money? You should have said that it is not my land.
No. I only.
Mainly because your name resembles with
no.
original landowner, you took the money.
No. There was no occasion to know that the land doesn't belong.
Why you don't know whether you have a land or not?
I'm saying, my lord. I was serving in Bangalore all through. My lord, that is the prosecution case, my lord. I thought that my father, who is dead now, might have acquired purchased the land, my lord.
That is why I placed the document before them.
Where have you said that? Show me. All these things are your defense.
No, defense not. That is born out from the charge sheet.
And see,
On the charge sheet itself.
Your land is not required. You participated in the what you call the award this thing and award amount you have taken. Merely because your name resembles with
not taken, my lord. It was released in my favor on the condition that I will return it on the.
You participated therefore only.
Because I was noticed. Had there been no notice, I could not have that.
Notice you should have straight away gone there. You should have said, it's not my land.
Milord.
But you encased the situation.
No, not.
Encased the situation, taken the money.
No, taken the money.
When you got exposed, then you returned the money. But
no.
Crime is done.
No, not in that way, my lord.
That is the fact.
No, that was, my lord, I am explaining, my lord. The land acquisition proceeding, when the notice I received, I found that.
Your reply to the notice you show me. Your reply to the notice.
Your lordship may kindly see, I have managed the notice.
In
my
notice was issued because your name resembles with the original.
No, not only name.
Name, father's name, whatever.
Father's name, address, my lord.
Maybe no.
How can
show me your reply to the notice.
No, how can a show moto appear before
I understand. You show me the notice, reply to the notice which you have given to the land acquisition officer.
No, reply I have not submitted anything. There is no necessity for a reply.
Then
I produced the documents, man.
Which document?
This certificate copy of the land records.
Show me that.
That has been mentioned in the charge sheet itself.
Where from you got the certificate copy?
From the authorities, the land authority.
You obtained that, produced, and took the money. Despite the fact that you are not the owner.
No, I was not aware that the land doesn't stand in my name, my lord. That is why.
Very, very difficult to be done.
Of course. The only question is
whether
there was a mens rea.
Yes, Mr.
There is no mens rea, my lord. On bona fide belief, I received and returned it.
If your lordship permits, my lord, that charge sheet copy, my lords, I put
yes.
Red lines, my lords. Your lordship, both this side I put some red lines.
Yes.
Lordship holding that particular red, unfortunately, that line is there.
Accused Nursing.
Accused Nursing Chandra Swai issued.
No, prior to that, your lordship, previous page. Unfortunately, another Arun Kumar.
Unfortunately, another Arun Kumar Mahanti so is a permanent resident of so.
Court matter deliver the notice to family member of Arun Mahanti, not actual claimant, who is working in Hindustan Aeronautic Limited as Bangalore Secret Officer. Lordship, the entire things confusion arises with the name of the.
I understand. Go ahead. His complexity I want to see. Yes.
Lordship, turn to the next page. Next page, my lords.
Next, we continue reading that part. As the Arun Kumar Mahanti had no original sale deed with him and not depositing the land cess regularly, he contacted the accused persons, namely Nursinho Charana Sahu, so, and all of them connived each other and advised Arun Kumar Mahanti to arrange a certified copy. That's what is the offense is, certified copy of the sale deed based on the compensation can be awarded so. And you knew you had no document. You obtained certificate copy, submitted that, took the money. With indemnity bond is obviously is a procedural thing.
My humble submission, man. But if the original document is not available or missing, can I not use the certificate copy, my lord?
But you knew that you.
No, I didn't know.
Where from I get it?
So I was all through in Bangalore.
Bangalore, but you don't know whether your father has purchased the property.
No, by the time
it is in your name.
Yes.
You don't know whether you have property or not. What are you talking?
Let me explain, my lord.
You don't know that you own the property.
By the time the notice was issued, my father was not there. He's dead.
The property was in the name of whom?
Arun Kumar Mahanti.
You are the Arun Kumar Mahanti,
yes,
according to you.
Yes.
And you don't know that you own the property? Can can anybody in the world believe
No.
that you don't know that
No.
you own the property?
No, I was under the impression that.
I'll tell you what had happened.
Fine.
Notice came to you because your name resembles with the name of the original landowner. And you encase that situation. Since you had no original document, the officers, the land acquisition officer and everybody said that get certified copy. You used your name impersonating yourself, got the certified copy, produced it, took the award amount. When you got exposed, because this is the procedure, indemnity bond has to be filed. Indemnity bond you had given. When the original landowner came to know my money has been taken by somebody, he complained, you return the money. But all these things you have already done.
That is the prosecution case.
That is.
Let me explain that.
What is there to explain? Can you explain that you had no knowledge that you own the property?
I say that. Why I say so? Because
Is it your case that your father has purchased property in your name?
Yes.
Where is that? How will I believe that?
I was under the impression.
Impression? That has to be stated in the trial only.
Let me.
On the basis of your impression, I can't pass it.
No, all right, my lord. Your lordship may kindly see the very same thing happened with the original order man. He was also not aware.
Where from I'll get all these things?
Here it is.
No.
In the charge sheet. In the charge sheet, I am not relying. I am not referring any other.
I can understand if you could have said that no, I am the original owner. He is not the only original owner. I can understand.
No. How can I say? When there is dispute, I immediately surrender the money.
If the prosecution concedes, then only I can do something. Yes, Mr. Das.
I'm my humble assumption. There was no.
But there is prima facie case,
Yes,
madam.
there is no mens rea. I have never defrauded him.
Why have you obtained certified copy?
Because the original could not be found. Because my father had died long since. That is why. So.
Is it possible you are working? What are you? You are working as
security officer.
Security officer. You don't know that your father has purchased property in your name. You don't know that.
Because my brother who has resided here, he was repenting before the authority.
All these things, sir. These are the disputed question of fact to be established in the trial. No. Can I presume everything, whatever you are saying?
No, my humble submission, only limited submission, that I received the money on good faith, that I the owner of the property, my land has been acquired.
That good faith, inverted comma good faith has to be proved in the trial. In the trial.
I order to. If there is any dispute, I will deposit.
This is a procedure.
Yes, my lord.
In every land acquisition proceeding, indemnity bond has to be filed.
I deposited the moment I was called upon.
That is the procedure. You have not done special thing.
No, I'm not saying.
In any.
No, at that time I did not contest. That is why I'm saying. Not that I fake claim, I led the fake claim. That is why I'm
Anyway, yes, Mr. Das, would you like to say?
I did not pursue the fake claim.
Yes.
Next point. Should turn to next page.
Yes.
And this is the essence of that chart sheet note. The accused notification of swine issued with the check number so and so amounting to 17,72,302 in favor of Arun Marti, who is his deposit bank. Lordship don't skip the other lines. The next red line, like when the matter came to vigilance and this case was under investigation, the accused Arun Kumar.
Now, how it came to the light? Let us see. During the investigation, the account statement of who has given the complaint? Who is the complainant here?
Yes,
who is the complainant?
Sarat Kumar.
That is by the vigilance.
Sarat Kumar.
By the vigilance.
Then he refunded the matter. That's why, that may be when he came to the vigilance, this case under investigation, the Arun Marti refunded the exact amount to the special level white account page so and so. That's why, my lords, only one point in his favor that there has been no pecuniary loss or.
Shall I record it in court?
There is no pecuniary loss or any kind of. But so far, other point the lordship raised, that's clinching the issue more. What lordship raised that point more. But with regard to the
because in the land acquisition award, you have to give an indemnity bond. He has given when she got exposed. When the money was taken. Money was taken in 2011.
Date 11.
And when he returned?
Returned in 13. 2 years.
13.
When he was
when the FIR registered?
FIR was registered
2012.
12.
After the FIR is registered, he has to refund, obviously.
No, not after the FIR. When I was issued notice by the land acquisition.
By that time, FIR was registered. Therefore, the refund, therefore, notice was issued to you to refund.
Only thing my humble submission that I did not pursue a false claim. Suppose had it been case.
Had it, if it is not a false claim, why have you returned then?
Because I was called upon.
Acha, it's so simple.
No.
You're making it so simple.
No. Because I was called upon.
You are called upon to take the money you have taken.
No, on the ground.
And you are called upon to return the money you returned. So therefore, everything is washed away.
On the ground that another Arun Kumar Mahanti has laid his claim. On that ground, I was called upon to deposit.
Anyway.
Accordingly, I have deposited the amount.
Anyway, okay. Okay, I'll pass the order. You should leave the number. इसके साथ देता है. Pass it.
Before.
If you want, do you have any judgment to support your case?
The place court judgment.
Any judgment? Will you come with some judgment?
I'll submit. If I have bona fide pursuing the bona fide.
Therefore, I don't want to, in between.
I'll submit.
So just put it up to 2 weeks. Come with some judgment because I'm myself is not convinced. Maybe you get one more opportunity. You may come.
So you're clinching the issue, my lord. But
that's the whole gamut.
It was difficult for him to resist the temptation of receiving it. The moment he came to know it doesn't belong to him, he reported back. No loss, pecuniary loss. But still, then
but the fact remains the conduct. The conduct shows that he is not a criminal. Criminal bent up mind. He was not. He doesn't
resist the temptation.
So therefore, I am trying to help you out, but that portion you have to. I've just put it up to a week or so. Please come with some judgment. Otherwise, I am not satisfied.
When he saw that 17 lakhs, he couldn't resist the temptation.
The
moment
normal human.
The charge sheet said the charge sheet said the postman delivered the notice of family members Arun Mahanti at Katak, not because not.
He got, you saw 17,000. 17 lakhs, he took it and gave an individual bond. Once you expose it, return it. He doesn't have that criminal bent up mind. See, but what I'm trying to say is 2011 he has taken. 2013 he has.
2013 notice was issued from the.
With interest you have given or same amount?
No, same. Same moment, and that too, Muller, when he came to know that another person, same name, age and father same.
But he has created that documents.
Their lordship is correct, man.
Certificate copy, everything you took and gave it. Anyway, you try and find out some.
When the original document will be lost, the only force is certificate.
No, you knew that you don't have the property. You are not the owner of the property. Therefore, the other people said that get certificate copy, we will pay you. You went and got certificate. Do the money.
No, only when this notice was issued by the land.
No, it's all right. I'm not.
Only one.
I'm not with you.
One good point is in favor, Mullers. There is no pecuniary loss to the company.
And this is
it's a reported back.
And the conduct is not criminal. This thing. Therefore, I'm.
Only the human instinct is difficult.
Human instinct is huge amount. So therefore, he might have done it, but there is no criminal.
And that two minutes, the other person in that ship, they died. And out of 4 or 3 died.
2 have died, and one. Just find out some judgment. Yes, good faith and bona fide belief. On that, at least. Something can happen. Yes.
The lawyer himself is a good soul. The lawyer is a good soul. And he has the highest number of cases in the trial court at Kota Special Court.
I think I'm sure that he'll get some judgment.
Yes.
Here, this is against discharge. Your lordship had heard this.
This is that case, your lordship had heard it. That will come up in the part-heard matters. At the earliest, the early morning, Mullords, I made a mention, not today only, Mullords. But my learned senior has provided me with the Xerox copy of so many documents. I was supposed to.
Only one document I would rely. I would just take 10 minutes, my lords. There's no case against these.
Then shall I put it after a week or so?
This, in fact, so many occasions.
I agree. I agree.
10 minutes.
It has, in fact, this is under the entire proceeding has been stalled, Lord. There I agree with
So,
him,
my
Lord.
lord, it's
This is
not-
a case,
we
shouldn't
lost
take it off.
everything.
Let it come.
But may I have
They
just
have
10 minutes? 10 minutes
So let
by
it-
the clock. I will not take a minute more. There is no case against these people. My lord knows once a vigilance case is foisted, their entire career goes. This is not about a case. Now, my lord may just give me 10 minutes. I'll just show a few documents. Even less than 10 minutes, my lord.
Day after tomorrow, better also.
Oh, 5 minutes रह गया.
No, but he has to be otherwise piecemeal. There is,
I think he would.
shall I put it on 13th?
No, let him just
13th.
listen to what I have to say, because there is something in this.
Just
Refresh my memory. It's all.
No, not refresh, my lord. There is absolutely nothing in this case.
Yes.
May I just show, my lord?
Yes.
Now, my lord may see the allegations against the present petitioners from the charge sheet itself. It is at page 54, 54, my lord. Their document. Page number 54 of your lordship.
Yes.
Now, that is from the charge sheet I am placing, my lords.
Yes.
After the first paragraph, second paragraph. During investigation, it was revealed that Sri Vijay Kumar Das was working as superintending engineer, Drainage Circle, SCDC, Baleswar, since April 2007 to 2009 and retired from service on superannuation on 30/9/2011. Sri Ajit Kumar Behra, he is one of the petitioners here, assistant engineer, ex-estimator of so-and-so, was working as assistant engineer, Moilbhanj Investigation Division, Udala. Sri Bipin Kumar Malik, the other petitioner here, is now working as so-and-so in so-and-so office, Delta Square, district so-and-so. Narahari Panda was a draftsman working since so-and-so. Now, these are the two petitioners before your lordship. Now, my lord may see what are the allegations. That I won't take your lordship time, my lords. My lord may kindly see page 56 on the right hand side.
Yes. Ajit Kumar Behra.
Just previous to first paragraph of that page. Further, Sri Narahari Panda mentioned in the note sheet that in continuation of his office letter number so and so, the financial bid of Sri Biswal, special class contractor, is opened on due date and time in presence of bidders and the authorized representatives. The rate quoted by Ramesh Chandra Biswal, being single bidder, is incorporated in the comparative statements. After checking total amount of Sri Biswal comes to 1,27,67,814, being 5.98% less than the amount put to tender, and Sri Narahari Panda put his initial with so-and-so, which has been deciphered from 30 to so-and-so. So, my lord may just take note that 5.98% less than the amount put to tender. This percentage is something important. Then, my lord may kindly see, Sri Ajit Kumar Behra, AE estimator, has given his noting mentioning that the contractor has quoted a rate of so-and-so being 5.98% less than so-and-so. He has furnished APS of 8,50,000, which was not required. This line of sentence has been inserted by him. Thereafter, PA so-and-so have put their signatures. The pre-qualification of so-and-so contractor has been approved by chief engineer post facto, and said contractor also so-and-so. On scrutiny of comparative statement financial bid, it was found that the contractor has deposited 8,50,000 as APS, and the date mentioned by the office president have put their signature showing the date as so-and-so through finance so-and-so. Similarly, the technical bid was opened. So this is the allegation. Now, my lord may kindly see next paragraph. See, Ramesh Chandra Biswal has furnished APS of 8,50,000 towards the additional performance security in the shape of FDR in so-and-so Baleswar, as he has quoted the rate of 16.22% less. So, originally it was 5.98. Now they say that 16.22 less. In order to give more benefit to the contractor, the quoted rate of tender amount has been manipulated by the draftsman, estimator, PA, and so, being connived with Sri so-and-so, and made it 5.98% on the previous writing of 16.22%. So this is the allegation. Now, my lord may kindly see the
16.22, you have manipulated to 5.598.
That is the allegation.
Yes.
Now, my lord may see the bid itself. The bid given by the tenderer. That document I have given today, I have given my friend also. today, if your lordship sees that the bill of quantity.
Is it part of charge sheet?
Yes, it's part of charge sheet, part of documents, and my lord may kindly see the bid amount.
Yes.
Now, the bid quoted in the list of dates, my lord may kindly see.
And come to the bid.
Now, my lord may kindly see the bid amount quoted. More of it. Flag mark, orange flag mark.
Yes.
Page 70.
My lords.
Bid amount will
Bid ta dekha tha apan. Now, my lord may kindly see the amount quoted by me is 39.39 at that page.
Yes.
Now, here the estimated rate is 42.20.
42.20.
See document ta dekhiye.
Where have we got it?
Establishment of cadmium both weight and drag condition.
That would be annexure 5. Annexure 5 at page 34 of your lordship's brief.
Comparative statement.
My lord. And in the bid itself, there is no overwriting. My lord, may kindly see annexure 5, the comparative statement. My lord, may kindly see that table. Total amount is, this is the estimate towards the bottom, 1,35,796,15. This is the estimated price.
It is not at all visible. What is this? The document is.
Get the page you're saying.
Well, it's page 34.
Annexure 5, I'm there.
Annexure
but
5,
that
towards the bottom, my lords. As per estimate,
yeah.
As per estimate, if my lord sees,
Comparative statement.
Cost comparative statement. As per estimate, if your lordship sees, it is 1,35. Towards the bottom, my lords, if your lordship would allow me, I can show it from here. Or the hard copy from the court file, if that can be taken. Here, my lords, towards the end.
Yes.
My lord finds 1,35.
Yes, 1,35,79,000.
Yes. So that is the estimated price.
Yes.
And the contractor has quoted 1,27,67,814.15. And below that, it is 5.98% less. So the bid itself contains this value. So if his bid is this, and subsequently while analyzing the bid, if we overwrite something, how does the criminality come? His original bid is intact. No overwriting in his bid. In the note sheet.
Where is that offending document?
This document, my lord may kindly see. This is the document.
No, this is not the offending document where you have manipulated.
My lord, no note sheet, my lord.
So where is that offending document?
I will show that. So my lord may see, this is the bid.
In the bid that
there is no overwriting.
That is 5.98 is there.
Yes. And the bid value remains intact. Bid value, nobody has changed. The contractor has submitted this bid, and in the bid, there is no overwriting.
Yes.
Reproduction.
Yes.
Now, if your lordship would see this bill of quantity given, there is no overwriting. It is clearly mentioned that these are my figures. So after this, if they overwrite something in the note sheet, then how criminality can be attributed to them? The bid remains intact.
Where is the entries in the note?
My lord may see the notes. That would be the additional affidavit, page number 74.
The charge sheet.
These are documents of the prosecution, additional affidavit, page 74.
Yes.
And page 74, your lordship may kindly see this amount 127,07,874 that has been overwritten. And then below that, we have also given typed copies of this document.
Where is the type?
But the original document, my lord may see, being 0.598% less than.
Where are you reading that? No page.
Page 74 of the additional affidavit. last time also we had shown this. It is under RTI, under RTI, you have got it. Original document. It's a part of that document.
Is it a part of charge sheet?
This, my lords, RTI, we have got it before this court.
No, it's
The
a
note sheet-
charge stage. I can't
My lords, this note
look
sheet is
into
the-
a document foreign to the charge sheet.
But this note sheet is the core document where criminality is attributed to us.
Then you can call for it for evidence.
No, this document is the part of their records. If this note sheet,
Maybe,
goes,
but-
then there is no offense.
Maybe, but because this is a document which you have obtained by in RTI.
No, for RTI, my lords, we have annexed. But
Where does in the
document-
charge sheet it say that the noting has been done on
Yes.
such and such day,
Yes,
whatever.
that, my lord, may kindly see. This is the basic case. The
This
case of the
this noting
prosecution.
dated, noting dated.
The noting, my lords, is dated 2710,
2710 and 2910.
my lords.
Let us come to the charge sheet.
My lord.
It's referred to
Which
this.
I referred to originally.
Hmm.
Your lordship may kindly see that document. That is page number 54. Page number 54.
Yes.
What I just placed, my lord. Page 54. These people were in charge, and the basic crux of the allegation is at page 56.
Where does it refer to these notes?
Yes. Opening line of page 56. Opening line of page 56.
Yes.
Further, Sri Narahari Panda mentioned in the note sheet. This is the note sheet that I was referring
So that
to.
is 27. It is
Yes.
23.
23, Narahari Panda begins the note sheet.
You show me that note sheet 2310. So it needs to be heard, not it is so easy.
My lords,
We have to show linking document unless
no,
you see
linking,
that.
my lords, this note sheet, the
It's
basic
not so
allegation,
simple.
my lords, what I'm trying to submit, I'll simplify this for you, lords. The allegation is that in the note sheet, we have enhanced the contractor's value.
What was the motivation behind making those notes, and what is the criminality, and what is the mens rea involved has to be seen.
My lords, may I
If you say that the
What I
bid
was
documents are intact, why these notings were made?
These were human errors. There is no benefit. Now, my lord, may kindly see how
Your intention may be for doing that. You could not have given it. That's a different story.
my lord, let me start with a clean slate. I'll just simplify this for your lordship. The contractor submits his bid. Thereafter, it is evaluated. First, the bid comes, then only evaluation happens. That's how the sequencing works. The bid values are intact.
It is a single bid.
Yes, it's now we'll go into the aspect of single bid. Whether
When it comes to single bid, all mischiefs are being done.
Yes, your lordship is absolutely
Therefore, the whole difficulty.
Your lordship is
Had
absolutely
it been a competitive bid, there is no problem.
My lord,
it is not a competitive
now,
bid.
let me get over this issue of overwriting. The allegation against these petitioners is they have overwritten to favor the contract. Overwriting is human error because the bid itself has the same value. Bid, no overwriting has happened. Bid is a prior document. After that, and in the bid document itself, if there are any overwritings, they say no.
That has to be seen whether bid documents were changed subsequently.
No, that is not their
manipulating
allegation.
all these things.
Their allegation. Now, my lord, this is one of the points. The bid is intact. There is no scope for any overwrite. Now, your lordship may see the other point which
Then it needs hearing. That's what you said 5 minutes. Then I thought it's not 5 minutes. It needs extensive hearing.
My lord, may I
Because it's many document you obtain in RTI, it's just see the voluminous document.
One document your lordship would remember. My lord may just see the list of dates. That list of dates. Page number 3 of today's list of dates. Page number.
Have you supplied this copy to him?
Given.
You just go through that. I'll put it.
My lord, may I submit one thing?
Yes.
If lordship may recollect. Initially, investigation took place on 24/4/2009. The DSP made 4 people as accused persons. Director Vigilance approves 4 of them as accused. The main chief engineer and all are there. After that, after 3 years, director's order is completely given a go by. The IO implicates the minions, and we are the minions before your lordship. This was the point that I had shown earlier. So director knows, the person who was supposed to be accused persons are completely given a go by. New small fish are brought in who have absolutely no role to play. The person who approved the single bid, he is let off. That's the reason, my lords, I had, if your lordship would remember, this is that case where the main kingpin is let off and you go after the minions who have absolutely no role. This my lord may recollect. I have
The
shown this-
noting started at your instance.
No, we are the middle, not at Narahari Panda is not a petitioner. We are in the middle. We have not recommended anything also.
Okay, well, put it for hearing. Monday
further hearing.
Monday further hearing. Monday.
But there is, my lord, here, my lord may recollect this point.
I understood it. That,
Yes.
that is the reason interim
Yes.
order is there. Interim order. Prima facie, you have a case. Interim order is there. Interim order to continue, put it for further hearing.
Afterwards, after 14th minutes. 14th is a holiday after.
Just wait for some time. We'll adjust the date and communicate to you.
Because
Yes.
here, my lord, we have a clean case. We are the smaller people. We are letting the chief engineer is let off. And this we are showing on black and white.
What I believe is you don't appear for smaller people.
My lord,
That's my belief.
Agree.
My lord, we also appear, my lord, for smaller people. Merely because I am designated doesn't mean that. My lord, the case, listen to this case. There is something why I am shouting at the top of my voice in this.
You have a case. I'm not saying that, but it has to be. The document has to be coordinated. That's the old
Give
difficulty.
me the benefit of doubt, my lord. That may be the reason I am appearing. Your lordship can take it that way, my lord.
Just the documents have to be coordinated. That's all. That's all.
We will.
And can you help me in the sense that prepare a compilation, convenient compilation, instead of going to additional document,
I
this,
will do
that.
But all
Prepare
these
a-
documents, I would do that.
Prepare a convenience volume so that I can
In
just
5 pages only we will do it.
yes all documents which are relevant.
Yes.
But pertaining to charge sheet.
Yes. This note sheet
You
is-
point out if it is not pertaining to charge sheet, I will not rely upon that.
Yes.
Yes. Next.
Interim order to continue.
Interim order to continue.
65 minutes, early morning I have mentioned minutes. The another co-accused case, your lordship heard and the judgment is reserved.
My lord, yes, my lord.
These two matters will be taken off.
Lordship had, my learned senior had requested that these two matters, item number 65, these two matters be detagged. And the first matter, that is Binod Bihari Das, criminal revision number 584 of 2022 be heard. And it was hearing has been closed in September 24 minutes. Judgment is reserved. We have filed written notes of submission. It is that case where, my lords, the allegations were with regard to the arithmetic and GK, and we were not involved in that. My lords, the 3 OS officers who were responsibility was thrown upon the OS officers when the collector and others were completely involved in this case, my lord. Regarding manipulation of mark sheets in arithmetic, GK, and we were given only for ODI. There is no allegation with regard. My lord, kindly see page 118. Okay.
In fact,
I'm making submission. Just
we'll
recollect,
open it-
lordships.
we'll open-
Page 118, my lords.
Let this matter.
I'm not
I
making
have
submissions.
reserved a judgment.
Yes, ma'am. I just page
Another
118.
another co-accused, my lord.
I'm not making any
No,
submissions.
full bhitar
Just
pasla
to
hai,
recollect,
ghar ko
ma'am.
jiva na.
I will not do that. I will not do that. That's page 118.
108, one
Again.
minute. I'll just see 100.
Lordship, it was a lordship specific query. Only to throw responsibility, why did you bring in these people? Now, Land was fair enough to say they have objected to it and the allegations do not meet their requirement. I must be fair to my land senior also.
108, huh?
118 again.
18.
Again. Adira case. Again.
Yes.
I'm sorry.
Yes, I'm there.
Aram Hochi, Sri Binod Bihari, serial number 2. Sri Binod Bihari Das, the then BDO Sadar, Sri Raghunath Mundari, Adir is a petitioner, in arguments, Binod Bihari Das, again hearing, sorry, Raghunath Mundari and Sri Ripnath Suna, the then
Lot of
BDO,
people are there.
and so were members of the records, revealed that order
Let
of.
me pass the order in that case.
Yes,
Because Bihari, you will get benefit
I-
directly.
Yes, ma'am.
Wait. Binod Bihari Das is there with I'll
Page 119 the specific role.
in fact, many cases I have reserved. So therefore,
I'm sorry.
trying
but
I'll Binod Bihari, I'll just see.
I'm sorry.
I can read it.
Recollect that.
Yes. both the matter can be over once I give dictation there.
I'll verify, my lord, what are the subjects. My lord. In that case, my lord, I tacitly submitted, my lords, that this subject was no, that was not that subject was not questionable. I mean, the question papers or all the tampers, my lord, but different subjects, my lord. So those things, in that particular case, case, my lord.
Only for ODI. I'm like, page 100. I'm sorry.
Both ODI.
Again, only ODI. Page 190 will clear. Page 190.
We'll distinguish. Let us. Let that check.
Page 119 will be very clear, my lords. Page 119.
I'll just check.
Again. I'll not make incorrect submissions, my lord.
Yes.
I'll never do that.
This, what about Ripunath Suna?
Same. Three US officers, my lord.
So then I'll issue the Bipin.
Binod Meridas, criminal division number 584 of 2022.
584 of 2022.
These two matters may be listed again after the.
No, it will be listed. I'll just see in the weekend.
Again. Interim orders to continue.
Interim order to continue. Yes.
Pardon. Item number 75 of the weekly list. This is a case of 2012 appeal matter. The appellant is in death bed. Can it taken up tomorrow? If your lordship permit. This is a small matter.
Death bed con problem con is.
Old age, 2012 appeal.
Good, you will get rid of.
Can it be taken up tomorrow?
Yes.
Of less.